Stimulus, I have six these that it is the doctrine of separability which was used to give a separate existence and then say that it is not amenable to stand.
Correct.
Now, may I invite your Lordship's attention to paragraph 7, which is volume 1, 297 page number. Convenience compilation 1, page 297.
That's right.
May I place? The next issue which is as to which authority exercises the power of impounding. In case where the substantive contract contains an arbitration agreement. In an arbitration agreement, the disputes may be referred to arbitration by three modes. A. The first mode is where the appointment of the arbitrator takes place by the parties consensually in accordance with the terms of the arbitration agreement or by a designated arbitral tribunal without the intervention of the court. In such a case, the arbitral tribunal is obligated by Section 33 of the Indian Stamp Act or the applicable state act to impound the instrument and direct the parties to pay requisite stamp duty and penalty, if any, and obtain an endorsement from the collector. Just pausing here. Section 38, when I will place it, has a proviso A that this can be done by the very arbitrator himself. Just make a small note. Section 38, the 35 proviso A. And if this is not done, only then 38(2) requires it to be sent to the collector. So the arbitrator himself can do it.
35.
35.
8.
35 proviso A of the Stamp Act. Not just to make a note, I'll come to.
No, let us see it straight.
Yes, straight away.
Only then we'll understand.
That's in Convenience Compilation 3, page 39.
You're talking about Indian Stamp Act. Isn't it?
Indian Stamp. Indian Stamp. Section 35.
Yeah.
Instruments not duly stamped, inadmissible in evidence, etc. No instrument chargeable to duty shall be admitted in evidence for any purpose by any person having by law or consent of the parties authority to receive evidence, or shall be acted upon, registered, or authenticated by any such person or by any public officer unless such instrument is duly stamped, provided that A. Any such instrument shall be admitted in evidence on the payment of duty with which the same is chargeable, or in case of any instrument insufficiently stamped of the amount required to make up such duty, together with a penalty of 5 rupees, or when 10 times the amount of the proper duty or deficient portion thereof exceeds rupees 5 of a sum equal to 10 times such duty or portion. Therefore, the person to whom such instrument comes, whether it is the court or the arbitrator itself, can assess the duty, take a penalty, and then go ahead. Now, let us contrast this with Section 38. Please contrast this with Section 38. Instruments impounded, how dealt with? Where the person impounding the instrument under Section 33 has by law or consent of the parties authority to receive evidence and admits such instrument in evidence upon payment of a penalty as provided by Section 35 or of duty as provided by Section 37, he shall send to the collector an authenticated copy of such instrument together with a certificate in writing stating the amount of duty and penalty levied in respect thereof, and shall send such amount to the collector or to such other person as he may appoint in this behalf. 2. In every other case, the person so impounding an instrument shall send it in original to the collector. So we have two modes. One, the person who sees it in the first instance, court or arbitrator, impounds, takes penalty, and proceeds forward. If he doesn't do that, 38(2) says it is to be sent to the collector. Now, your Lordships may have, coming back to paragraph 7 of the judgment. B. The second mode of appointment is where the parties fail to make the appointment in accordance with the arbitration agreement and an application is filed under Section 11 before the court to invoke the default power for making the appointment. In such a case, the High Court or the Supreme Court, as the case may be, while exercising jurisdiction under Section 11, would impound the substantive contract which is either unstamped or inadequately stamped and direct the parties to cure the defect before the arbitrator or tribunal can adjudicate upon the contract. Therefore, in my respectful submission, it is impounding payment of stamp duty and only then appointment of the arbitrator, which should proceed because actually you are acting upon that instrument by appointing an arbitrator or by referring the parties to the arbitrator. Now, see, the third mode is when an application is filed under Section 8 before the judicial authority for reference of disputes to arbitration, since the subject matter of the contract is covered by an arbitration agreement. In such a case, the judicial authority will make the reference to arbitration. However, in the meanwhile, the parties would be directed to have the substantive contract stamped in accordance with the provisions of the relevant Stamp Act, so that the rights and obligations emanating from the substantive contract can be adjudicated upon. Now, my reading of the paragraph is that an order under Section 8 has been finally made. Parties have been relegated. It is now the time gap between the order making Section 8 and Section 11 application that the parties have to pay the stamp duty. In my respectful submission, my lords, the judicial authority cannot, lords, make an order under Section 8, a final order under Section 8, unless the instrument is duly stamped, because it is inadmissible and it cannot be acted upon.
There was a very strange kind of dichotomy.
Yes.
You find in Section 33,
Yes.
clause B to the provider. A little,
Yes.
where
Where any person from whom a stamp receipt could have been demanded.
no, we are reading where?
Section 35.
33B.
33B, I'm so sorry.
33(2)B.
33(2)B. Yes. In the case of a judge of a high court, the duty of examining and impounding any instrument under this section may be delegated to such officer as the court appoints in this behalf. This one judgment which I'll cite.
Why judge of the High Court can delegate it
To an officer of the court.
So what you're saying is, supposing it's a 11 application before this court,
Yes.
the Supreme Court cannot delegate it.
It can be used.
No,
The word below it has to be
why this is so is that it was Section 11 was not contemplated at that
earlier.
time. See, Section 11 Arbitration Act, this jurisdiction, kind of original jurisdiction, but even otherwise, say for example a suit
Yes.
between states under Article 131.
Yes.
The original jurisdiction is there with the Supreme Court. So supposing a document is produced by one of the parties,
One of the
states, that power to delegate it is not ceded to the Supreme Court. They're just wondering why. It just brought your notice.
Yes, please. I appreciate it. My minutes would be perhaps it's a case of an omission. Once you omit, perhaps omission in the sense that this should have been amended. Once you have conferred it,
That's exactly what you're trying to hint at.
it should add also the Supreme Court because the act applies.
Yeah. Just say original suit by a state under Article 131.
It would apply.
So instruments will be produced, which may not.
Yeah, in the original procedure.
Yeah.
I'm grateful. I'm grateful. Now let's please have 7.2. Now the dichotomy again. In case of an application under Section 9 of the Arbitration Act, 1996, the situation would be different. If an application for urgent interim relief is filed under Section 9 before the court, and it is brought to the attention of the court that the substantive contract is not duly stamped, the court would grant ad interim relief to safeguard the subject matter of the arbitration. However, the substantive contract would then be impounded and the concerned party be directed to take necessary steps for payment of the requisite stamp duty in accordance with the provisions of the relevant Stamp Act within a time-bound period. It is made clear that the payment of stamp duty on the substantive contract, as assessed by the collector, would, however, be subject to the right of revision/appeal available under the relevant Stamp Act. Now, in 9, you are actually acting upon that instrument and granting interim relief. If the agreement, the instrument forms part of the court record, and that is relied upon to show what is the subject matter of arbitration. So in 11, you cannot act. In 8 and 9, because 8 makes a very curious case that it can be done in the meanwhile. So, because is it a case of preemptory order?
Sometimes in a suit,
Look,
if there's a urgent application, there's the undertaking giving for depositing deficit court fee, but on that basis,
that is why
it's acted upon.
it can. Now, that in my respectful submission would be relatable to 35 that proviso A, that it is a spot assessment, collection of the penalty, and then the court moves ahead. It moves ahead. Now, Millers, with this, please have the operative portion of this judgment. In fact, para 9, where the writ petition is actually dismissed on the
Who
ground.
will make the spot assessment?
Because it is the right. It is the court or the person before whom the instrument is produced. Because he is to now admit it in evidence and or act upon the instrument.
It would be in the nature of a victim
Yes.
assessment.
Right. In interim. Because I will place
Authority is the collector.
collector and then the chief revenue controlling authority. That because I will show once I place 44 and 45. In law, section 29 says by agreement you may say person A is liable but person B will pay. If I am an applicant in an application under suppose 11 and this defect comes, I can pay the stamp duty even if I am not liable to, and I can make it a part of my claim. And then I can also approach the chief revenue authority saying that please refund a part of the duty, a part of the penalty imposed. That is all permissible.
Then also the next question, the main question is, now what is the meaning which could be ascribed to the word expression acted up?
Yes. According to me, because acted upon means if you are called upon to exercise power. Suppose in section 8.
Similar expression is being, I think that it is used under say 115 of the Evidence Act. There that word is there, act up.
Because act upon means when you,
What could be the meaning which could be ascribed to that word?
Because
That is that's also relevant here.
yes, no, because
That
one is
point
admissibility,
but
one is admissibility in evidence, and then
then act up.
act upon. Now,
So
means-
that is also a crucial.
because act upon in my submission would mean, suppose it's a section 8 application. What is the party asking the court to do? That sir, this is the instrument containing an arbitration agreement or standalone arbitration agreement. Please relegate the parties to arbitration. So once the court does that, is it not acting upon the instrument or acting upon the arbitration agreement? So this is, according to me, Milos, is the concept of act upon.
One distinction I like to say,
Milos.
whether there is a clause in the contract of arbitration
No.
or there is a standalone contract agreement,
Yes.
is one and the same thing. Because either section 7 or 14.2. Okay.
Just checking. That word is there.
This judgment and
And
then
then global.
approval. The distinction is made that the substantive contract is its own place, stand, unstand, because dispute substantively arises from that contract.
Right.
But to initiate the process of dispute to be examined by the arbitrator, you have to put something in the pipeline. Okay. Now, a standalone contract agreement, even if it is unstand, we find that validity is not there. It is only existence of agreement. 11A, 6A.
Milos, may I-
And if you compare it with this, if only you have to examine the existence of an agreement, rest all where is the trigger is existence of an agreement, must be signed by the parties, and then this must include the clause of arbitration
Yes, ma'am.
and prima facie the satisfaction of the court by initiating to appoint the arbitrator must record the satisfaction that yes, the arbitral disputes arising from this contract. Otherwise, what will happen? Everything will be stuck. And the process which the legislature thought to conclude within 30 days of the service
Right.
under
Yeah,
13,
11.
11, 13,
11.
or asking the arbitrator within 18 months in 29A. We are completely frustrating it. And you will find that's why validity is not there.
That's right. Milos, may I just point out? He
No,
stands
Mr. Goel, just a supplement to what my brother Rastogi is asking you.
Look.
In the context of what is incorporated in 6A 11, we are in, I think, Jura Falgura, I think, was it?
Yes, ma'am.
They said that we are to
Nothing more,
look
nothing
into,
less.
we are to look into the existence of the arbitration agreement. Now we are trying to look into a situation where the agreement or the instrument concerned is subject to levy of stamp duty and adequate stamp is not there. So it is inadmissible in evidence. That's the implication. But existence, we are looking into existence. You are obliterating the document, instrument. Is that the understanding if stamp duty is not paid?
In my submission, Milos, the bar is admissibility in evidence for any purpose. The words used are inadmissible in evidence for any purpose.
We are talking about admissibility and we are talking about existence.
Right. Milos,
It's an existentialism question, if I may say so.
Because that is why, because when Galwale uses the word, it exists for a purpose. That is why, Milords.
No, purpose you can't bring in. The particular document is in existence, physically it is existing.
Yes.
It is physically existing,
Certainly.
but it is inadmissible. I mean, there has to be a distinction between what is existing,
Existence
what
in
is
fact, existence in law. That's
fine,
the
fine, no
crux of the
difficulty,
matter.
no difficulty, no difficulty.
Existence in fact, Milords, is something which we cannot dispute because it is printed or it is contained in the instrument. That's an existence in fact. But the bar applies to admissibility and acting upon it. So it does not exist in law. Can you enforce it?
But standalone arbitration agreement will have a different connotation. But an arbitration which is part of an instrument of another transaction, it will definitely have another connotation. You can't be equating both on the same footing. Standalone arbitration agreement, I would perhaps understand your argument.
Yes.
But if the arbitration clause is part of an instrument which is relates to another transaction, some contract, some supply, anything. So there, the implication of non-admissibility may have something to do with the transaction in question or the commitment of the parties
It is
vis-a-vis
the
each other.
instrument. Milords, it is the
No, correct.
instrument as a
Stamp is
We are
variable
not-
on the instrument. One would understand that. There's no difficulty.
Milords, therefore, what I submit is existence in fact of an arbitration agreement in a document. You cannot deny that. Existence in fact because it is printed. It exists as a matter of fact. But as a matter of law, it exists for permitting the parties to act upon them. It exists not only as a merely ornamental value. It is put into that contract for a particular purpose to relegate the parties to arbitration.
So
That's the purpose.
are you saying that no, it can be legally, it can be taken that it is in existence only if it becomes enforceable?
It is.
That is the short condition.
What is the sum and substance? Because look, it's-
Legally, not factually.
it is a rig. The bar is very temporal, if I may put it this way. The bar is created because it is
So
not.
factually, it is printed and therefore it is in existence. The contention is that in the legal sense, one can say that it is in existence only if it becomes enforceable. That is the condition.
That is the submission.
Tell us one thing.
Yeah.
You see 6A, this only talk about existence of agreement.
Yeah.
Right? Come to 16.
16.
The
6A.
6A of 11.
Yes, ma'am, I have.
And then 16,
Yes.
the emphasis is on existence or validity of the agreement.
And this is part of a larger
No,
concept.
we are different points. Now, existence you can borrow from 6A, and then 16 also. Correct? But when the emphasis here is on validity also,
Right.
if something is more to examine.
More.
So 16 comes into play after post reference, not pre-reference.
You are before the tribunal.
Post reference.
Yes.
Post reference. Now, if in post reference, existence or validity both have to be examined, post reference. And in pre reference, only existence of agreement to be examined. So our request to examine it. Then what more is to be looked into by the in post reference in reference to validity of the agreement?
Yes. I'll examine that. Look, my only.
If existence is in 6A, post pre reference, and according to you, it is if it is not duly stamped, insufficiently stamped, it is not a document in law which can be made admissible. This is your stand.
Yes.
Okay, we'll proceed accordingly. Suppose, as we said, this standalone agreement in both the contexts, whether it is a clause of arbitration in the contract or it is a standalone agreement, is one the same thing because 7 says agreement and 14.2 says even if it is a clause in the contract, still it is a standalone.
Yes, it is.
So, and that contract in which it contains the clause of agreement, this arbitration, that is stamped, may not be according to one of the party disputing it. So, in every case, whenever there is an objection, the first and the foremost question to be examined either is 6A or not, then 16, post reference, to be first examined as to whether the document is adequately stamped or not. Then our request is say jurisdiction and 16 jurisdiction is not overlapping.
Let's, in my submission, if we look at six, let's,
One way of looking at perhaps would be keep the hidden rule, the mischief rule. Why was 6A incorporated? 6A was incorporated perhaps to minimize judicial interference at the stage of section 11, the bare minimum, to find out whether an arbitration agreement exists or not. Because of earlier judgments which permitted a
SBI
kind of a
and,
more
Bugatti.
intrusive kind of jurisdiction, that was sort of be, the width was sort of be cut down. When Parliament makes a law and or brings about a change, one of the presumptions that it is aware of the existing provisions of the law. Now, Parliament must therefore be aware of Section 35, 34 of the Stamp Act. It could never have contemplated that a document which is unstamped would be allowed to pass muster through the window of Section 33, 34, 35, 36. Ignore all that. And Supreme Court, when it is functioning under Section 11, is equally bound by Section 33 and 35. And therefore, if a document is unstamped, it must do what it is bidden to do under the law. The other areas of interference which brought about the Section 6A, led to the introduction of 6A, of course must be borne in mind.
the limitations which are now.
Yes. Otherwise, we will be ending up doing what the law says you shall do. I mean, you're not doing what you're bound to do.
Indirectly trying to, let's then put it this way. This act, the Arbitration Act has been amended substantially, n number of times. If this was the intention of legislature, it could have provided in section 8, 9, 11 that the provisions of Stamp Act will not apply. If the court is not supposed to look into it, the document, and is not supposed to be bound.
And then global says so.
It carves, in my respectful submission, it carves out an exception where the legislature did not think it fit. Otherwise, because the Stamp Act 35 would have said that nothing of this will apply to the Arbitration Act.
Because section,
and both are central statutes.
When you talk about section 16,
Yes.
it contemplates parties appearing before an arbitrator without section 11 or 8. Oh, see, you can go before the arbitrator.
Yes, by consent.
By consent.
By consent. And at that stage, the bar.
You are participating in the appointment process, but the section 16 says you will not,
You
that
will
will
not
not
go beyond.
preclude you, prevent you from raising the
This objection. I'm grateful for this because Mr. Lordships directed us to reformulate our questions. This is what I thought, that legislature is supposed to be aware. If you look at the Contract Act, it is 1872. Your Stamp Act is 1899.
Yeah.
If the intention was to pull the concept of null, void, everything into the Stamp Act just because an instrument is not stamped, it would have provided that instrument. Now, the only consequence is 35, inadmissible, not act upon. Therefore, can you pull concepts of the Contract Act into the Arbitration Act or into the Stamp Act?
At the state of determination. See, post-reference is an adjudication.
Yes.
Question of determination. But 6A there is no determination, no adjudication. So if 35 is read in a manner to come up at the stage when there is an adjudication taking place, you can't make an evidence. You can't make the document admissible in evidence at the stage of adjudication. Because 6A is not adjudication.
No, but 6A is not really mechanical. That just see and then.
It is not adjudication. May not be mechanical, but not an adjudication. When you adjudicate, that comes to 16. And that's why the 16 contemplates jurisdiction, existence, validity, because post-reference in adjudication, the arbitrator or the person concerned has to first record a finding that all admissibility of the document relied upon.
It's legally valid.
Yes, legally.
It's legally valid.
So we are talking about post-reference. Now we are at the stage here in pre-reference.
Pre-reference.
Now our only question here is, if what is to be looked into about post-reference is also to be examined in pre-reference, then what is left for the pros reference to examine after the pre-reference adjudication is taking place?
The answer, my lords, I can give what I can give. Lords, please look at 8 uses the
Then what is happening is 30 days time after reference, after the service in the level 6A. The judgment says give 45 days.
45.
Now question is we are ourselves modifying the legislative wisdom which can't contemplate. You see, now in judgment say 45 days. Now in 45 days the man is not able to get the document stamped. I think this wrote in judgment.
Yes, just
You
let's
said-
Karwade. Let's
Last paragraph, 45 days. Now, the legislature say no. I give you 30 days time after service of notice in exercising of power 6A and conclude and make a post reference. Now, this judgment says we are granting you 45 days for what?
For the collector.
Meaning thereby that 30 days period is over and above 45 days. Now, question is this judgment take away the legislative wisdom and modify subsection 13 by saying the sorry. Since we want a legal document to be executed as a pre-reference say, so no, sorry, you can't proceed, send to the collector, 45 days time, send the document back to us and then we'll proceed.
But this is.
Is something a dichotomy here?
Answer this. This presupposes that the court itself is not exercising 35 proviso A. And then it is not collecting. And it is only then it is sending to the
The High Court said you can appoint agency in 33 to
It's agency. It's a
person.
It's a registrar. It's a registrar. Normally, because one judgment that has come before your lordship is not a registrar. The court said you will not look into the nature of the document because that is determinative of the duty which is payable. Your lordship have said it.
Then what is the validity? What includes validity?
Lords, may I just put it this way? Lords, these section 11 is a power which is vested in the High Court and
This court.
the High Court and the Supreme Court. Now, Lords, to say that I will not even look into a document, or I will just look at whether it exists in fact and refer you to arbitration, refer you to an arbitrator. And Lords, will it not be, Lords, in my respectful submission, a breach of a mandate of section 35? 33 first and then 35. 33 makes it mandatory to impound. 35 makes it that you will not act upon till you collect the duty. All this is preceded by a violation of law in the sense that there is non-payment or insufficient payment. Therefore, all this is to be brushed aside, pushed under the carpet and then send it to the arbitrator. Now, that's why I put it in the first instance. Your lordship's order, sending a document to a collector or the High Court's order, sending it to a collector for valuation, assuming that 35A proviso is not gone through. The collector, Millards, would do everything to get it done within 45 days or any other limit that your lordships put it. Is the same, Millards, to be expected from an arbitrator? If an arbitrator writes to the collector, I'm only assuming if we are now on a practical aspect, working aspect of it.
Post reference collect the arbitrator himself can do it. He's not supposed to
Right.
refer the matter to
The
collector.
same thing for the court. The same thing for the court. The collector comes in, that's why I'm saying 35 and 38. 35 and 38. 35 is,
Normally the person who comes with a request for reference, he would be keen to have.
no, that's why. May I just place it that way? Because if you look at section 45 and 44, they say you pay. Even if it is not your liability, you pay. You can adjust it or put it in your claim, in your suit or arbitration or whatever it is. Number one. Number two, if you have any qualms about it, 45 permits you to make an application to the Chief Revenue Controlling Authority for refund of duty and penalty. So any person, any applicant who is eager to initiate the arbitration process, he will just say, okay, according to me, 10 rupees is payable. According to you, 100 rupees. I will pay 100 rupees. Let us go on with the arbitration. Let us go on with the arbitration. And the differential amount, 90 rupees, I will put it as costs in my claim because the section permits it. The section 44 permits this. 44 of the Stamp Act. 29 is very clear who is responsible to pay stamp duty. subject to an agreement between the parties. If divorce that you come ahead and pay, you can claim it.
The problem is slightly different.
Look,
If there is a clause of arbitration in the contract,
look,
standalone agreement, what is it, 10 rupees, 5 rupees, annas are there.
yes,
Annas we convert into rupee, now come to 5 rupees, whatever.
look,
10 times penalty, maybe 50 rupees. No problem to it. But what is happening is, practically, the ground reality is, courts are not able to proceed because the clause of arbitration in the contract, until the contract agreement itself is not being adequately stamped, and the valuation takes time of the contract.
that's.
And that's why the courts are not proceeding to initiate a case.
Mind and a legally trained mind of a judge to do it, rather than leave it to an arbitrator. And again, the issue will arise.
But this line of argument, we can't be overlooking what is the objective of this enactment.
Yes.
We have borrowed the UNCITRAL model,
Yes, please.
which speaks about an efficient arbitration proceedings.
Yes, please.
Now, if we are going to put spanners at the stage of Section 11 exercise of power,
No.
then are we actually looking at an efficient arbitral proceedings?
Put it a bit differently. Are we, going to follow UNCITRAL model to an extent that we breach our own laws?
No, we are not
That-
talking about breaching our own laws. What your argument is in the context of the Stamp Act,
Yes,
which requires you to levy the stamp payable, right? So are we breaching the Stamp Act? It is inadmissible. That is the bar under the Stamp Act.
plus not
No, correct. And the examination is also Section 16, as my brother Rastogi has pointed out. Section 16 scrutiny post appointment is also available. So therefore, don't put it at a level that are we overlooking our own law? It is not like that. How can you be saying we are overlooking our own?
In my respectful submission, the statute creates a bar.
On admissibility. Evidence.
Step forward. The statute creates a bar on whom. It applies to the court, it applies to the arbitrator. There's a judgment by my Lord Justice Rastogi, which was a party, that Ganga Appa, that there is nothing in the legislative scheme of the Stamp Act to show that it would not apply to courts, or it is applicable only to the arbitrators. Number one. Number two, there is a judgment of this honorable court saying 33 provides impounding. Impounding is mandatory. Because with these concepts coming in, impounding becoming mandatory, and then saying
There also you just again see Section 33
33.
of the Stamp Act.
Yes, please.
It says several, that is officer, the authority, etc.,
Yes,
before whom any instrument is produced.
yes, please.
Except a
Now,
except a police officer.
etc.
Yes.
Now,
That is a
consider this thing. As long as this Stamp Act is made applicable to the proceedings under the Arbitration Act, and then take note of the fact that there are two proceedings or two ways to reach up to the stage of a 16. Because most parties make one consent without the intervention of court, go there before the arbitrator, or for appointment they may approach a court.
By consent of Section 11.
So, be it under Section 11 or directly by the consent of the parties. Question is whether once it is produced before a court or before the arbitrator, at the first instance itself, the impounding should take place or not.
Yes. According to the respective submission is yes.
It should take, because 35 says otherwise it is inadmissible and therefore it cannot be acted upon or enforced. It cannot be enforced.
Correct.
So the contention is that whatever the way, once it is produced, be it before the arbitrator or before the court, in terms of Section 33, impounding should take place.
That is the mandatory.
That is, you have some answer, so it appears that that is your.
That is.
So merely because it is produced at the stage of 11 or parties are approaching the court, the court need not relegate the parties to after appointing the arbitrator. It can on its own.
Yes.
That is the condition.
That is my submission. That is my submission.
Then
And
that will take you back to a fundamental question,
Yes.
which is if you read section 33,
Yes, please.
that's the first two lines.
Yes, please.
Every person having by law or consent of parties authority to receive evidence. Now, when a court, be it the High Court or the Supreme Court in a domestic or an international arbitration, deals with an application under the Section 11, is it an authority having by law or consent of parties authority to receive evidence? Is evidence being received in when you deal with an application under Section 11? Because that is the
Your
crucial
Lordship,
condition precedent to apply Section 33 as also perhaps Section 35, because their acting upon is also there. But otherwise, will you say that the court is receiving evidence in Section 11?
Let's see.
We just want to know because
Yes.
it's crucial to it. Because
The-
once it is authority to receive evidence, then perhaps it is inevitable
let's-
that
the
you have to
evidence
necessarily
is
impound the document.
evidence is followed by a comma.
Ah.
Evidence is followed by a comma. So it's a complete sentence, if I may say so.
Yeah.
Every person having by law or consent of the parties authority to receive evidence, comma.
It is the authority to receive it.
So first class. And every person in charge of a public office, second class.
That's right. If you're going to say that the court is comprehended within the expression
First
of
expression.
charge of a public office,
No,
No.
the first one. The first one.
so authority to receive evidence. So authority to receive evidence in the context of Section 11, does the court ordinarily or is the court expected to receive evidence?
What's evidence was of we are in my written submission approaching it only restricted to 11.6a. It can only be 8, also 8, 9, 11.6a. Now, let's 11.6a in the sense what? It is evidence of what? It is an evidence because that there is an arbitration agreement. So please refer the parties to arbitration and appoint an arbitrator. Evidence of what? Evidence of an arbitration agreement
That's right.
and requiring appointment of an arbitrator.
Does it boil down to receiving evidence?
We are receiving evidence,
Is it
the instrument as evidence.
because you don't deduce
No, it's-
oral evidence?
I understand. It's
Evidence.
not the trial court and the criminal court.
It is, but it is evidence still through the affidavit, I take it. That you produce, because it normally, for example, in Article 220,
Yes.
what is evidence? The evidence is the affidavit evidence.
Affidavit evidence.
That is evidence action.
Yes, please.
Can call the other side for cross-examination. If you file an affidavit,
Yes, please.
in an approved case, it has been done in Kerala High Court, where you've taken evidence in oral evidence, of course, we have taken. But this has to be
Yes, in
just
my
dealt with by you.
Huh.
We wanted to
Yes. According
just
to
get the stand back commentary. Stand back commentary.
This is Maharashtra stamp.
Any decision under Section 11 as such, I mean, under 33, I mean, under the Arbitration Act? 33, under 33 connected with the,
because 33, I can show Milos 2019 volume 3 SCC 788. But I'm sorry, but that's not in the compilation. 2019 volume 3 SCC 788.
What does it say? 2019.
19 volume 3 SCC, page 788. This is my lord, this is Ashok Bhushan and my lord, this is Vastu. I'll just read the relevant para.
Which is the para?
Let's para 14.
गलत गलत जजमेंट पंजाब के साथ डिपार्ट और आवेदन करवाते हैं
Because my first raised the issue as to whether the penalty which was provided in 35 is negotiable. The court says no. Your Lordships, I have 2019 volume 3 SSC. Straight, please come to para number 14 at page 793. Last about,
You read it, I'll follow.
yes, ma'am. Last about 7 lines. Section 33 applies to every person having by law or consent of the parties authority to receive evidence and every person in charge of a public office. Thus, Section 33 covers a host of authorities, persons before whom instruments are filed. The legislative scheme does not indicate any distinction between a court receiving an insufficiently stamped instrument in evidence and other authorities. All have to impose penalty of 10 times of the duty for deficit portion if it exceeds ₹5. This provision is for the purpose of maintaining the uniformity in imposing a fixed penalty of 10 times without adverting to any adjudicatory process regarding quantifying the quantum of penalty. The statute gives discretion to the Deputy Commissioner, who is the authority envisaged by the Act in charge of the revenue administration of a district. Then it is the discretion only of the revenue officer. Once the penalty is provided by the statute, it has to be imposed, and all the section 33 would apply also to courts. That's why I'm
So this can be seen, this section 13, if you are reading it and splitting it. No, this view virtually. No, this is correct because first, see, every person having by law authority to receive evidence. Second thing, every person by consent of parties authority to receive evidence.
Yes.
To
arbitrators.
and then so they are not only the authorities. Who are there? Next one, and every person in charge of a public office. Then exceptions. Before whom any instrument or chargeable in his opinion with a duty. So all these. Question is before any of these person categories. If it is produced, then they can impound in way of a section 30.
They have to impound. They have to impound.
They need not or they cannot now relegate it to a they are bound to that.
They are
See, there are two ways of looking at it. When you read section 33, it says, having authority, every person having by law or consent of parties authority to receive evidence. Stop there. Now, the fact that it was taken a judge of the High Court is very clear from the proviso, because it enables him
delegate.
there also can be, we can bear in mind that certain high courts have original jurisdiction.
Yes, Bombay.
Bombay has,
Bombay.
Calcutta has. So it could perhaps be, so we come back again to the opening words of section 33, and it's perhaps susceptible to two interpretations. Firstly, every person having by law or consent of party authority to receive evidence is general. For example, this court can take evidence in a suitable case, in a suit.
Straight through.
The other way of looking at it is the proceeding in which the document is produced, whether he has by law authority to receive evidence. There are two interpretations. So if it, in the latter case, in a section 11, it is not the practice, nor is it the law that you actually take evidence. Then how would section 33 apply?
No, may I
Just wanted to.
may I just place it? This means word evidence. If we look at the definition laws under the Evidence Act laws, it would mean examination in chief, cross-examination, re-examination again. But we are now dealing with a section 11 application where the document, the instrument itself is evidence. Because your arbitration agreement is contained in the document, the instrument itself. So the court is receiving the instrument in evidence or as evidence of an arbitration agreement.
But one more thing.
Yes.
There, see, we read that three categories. Every person having law authority to receive or by consent of parties authority to receive, and every person in charge of a public office. Then, once it is produced, the satisfaction should be only on one thing. That is, if it appears to him that such instrument is
Not
duly stamped, then the word shall used therein, it is having its own importance.
Yes,
because once it is produced and this is the satisfaction, then it is not sufficiently stamped. Then the word shall impound.
I'm grateful. Oh, your lordships just have volume 3.
Therefore, that shall impound means they have no other option but they.
I'm grateful. Just have volume.
Is it the constraint
Lordships are held.
in which it should be constructed?
Yes, your lordships are held so. Volume. Your lordships may come straight away because the judgment is Government of Andhra Pradesh versus Sri Lakshmi Devi. I'm relying at para 16, page 104.
Can be no dispute about it. They are bound to. I mean, the section is very clear.
Very clear.
I mean, does it
There is no
require
discretion.
doesn't require any judgment. It's bound
Just
to.
in case.
Shall impound.
The only
Because
question is whether it
though
is
the
actually
purpose
about-
of stamp duty, though the purpose of stamp back is fundamentally to see that revenue is being collected. That, that you also can see to it. The document which is unstamped. At the time, particularly when the Stamp Act was introduced, it was a very important source of revenue. Documents.
May I just say this? It took a judgment of your lordships and sewage lamps to kill this, this process of transferring immovable property by power of attorney, will, affidavits. The law was already very clear.
Absolutely.
It was very clear. But it took a judgment of your lordships to put an end to all this.
Suraj lamp.
Sewage lamps.
Yes.
That you will not transfer immovable property by this method.
Absolutely.
Sale deed and a duty, registered document. Law was always very clear.
Revenue, there should be no revenue loss. At one time. But at the same time, you have to harmonize that when there should be no revenue loss at one time, then the arbitration should also go on.
Certainly, Manoj.
And by the time it's finally culmination into an arbitration award,
Yes, ma'am.
whatever the revenue is required over the document in question, stamp duty, that period also must be consumed and the document must be duty stamped. If you put something, a rider in between, that no, sorry, you can't proceed, everything has to be stalled unless you do it first,
Manoj, may I
then the system is not become workable.
put it this
We
way?
want to harmonize
Manoj,
Efficiency.
efficiency
come to the Stamp Act. I will show Manoj
and to make the system workable. And what is happening is, under this legal jugglery, we are putting everything in a corner where the system is not working.
In fact, Manoj, the parties themselves are responsible.
No,
If we
that's
go-
why they are here.
if the, Manoj,
That's why they are here, but we
let me
not
put
to.
it very clearly. I'll take the lordships to a Stamp Act.
You see, you argue your case first, to whom you are representing. Okay, you argue it first. And then as an officer of the court to provide us assistance, as Mr. Gaurav Banerjee has done it,
Yes,
how to streamline,
yes.
taking the ground realities in there, and to see that the system made within the four corners of law, workable and effective. And there should be no delay. And no revenue loss at the same time. Because otherwise there will be revenue loss, which should not be there.
Ultimately, because all this money goes to see a consolidated fund.
That's correct.
It is our
That's
our
correct.
benefit, our infrastructure.
So we have to examine totality.
Suppose that is protected, the realization of the stamp duty is protected. We are asking you to suggest us a methodology whereby the efficiency of the arbitration process is protected, as is the objective of the amendment and bringing the ancestral.
I'm sorry
Yes.
to interrupt, my lord. May I say this, my lord? Your lordships are putting to my learned friend and impliedly
To you
putting
also.
to me that in the guise of adopting ancestral, we should not blindly ignore some provision that is in the statute. That was something which was bothering my lords. My lord, I mentioned that, my lord, I have circulated a note. I'm sorry I did not read it out, on 35 to my lords on the 19th, which, my lord, which explains 33, 33.2 and 35. My lord, if your lordships have a look at that, perhaps this, my lord, bogey that the appointing authority must do this on day one, my lord, that seems to be the burden of the song, may not be, my lord, strictly correct. Your lordships will have a look at this. My lord, I have also.
We are looking back actually. That while entering into the contract, it should have been stamped. Not that the authority at the first instance.
My lord, while
Looking at
entering into the contract, it should have been stamped, my lord. But the short answer to that is, while entering into the contract, it need not be stamped if you don't have to go to court, because all the obligations, rights and obligations are valid, my lord, and they are to be
You
executed.
don't have to go to court, then you escape scrutiny by any authority.
So, my lord,
But your obligation to
the obligation
Yes,
to
sir.
pay, my lord, is captured when you come before an authority. That's right, my lord.
no, obligation doesn't Obligation comes when you are entering into the contract. The scrutiny as to whether that obligation has been
Well, not there.
discharged or not, that you can escape if you don't come to an authority.
My lord, may I put it differently? The stage at which I enter into the contract, my lord, there is no dispute regarding the validity of that document or that transaction. That's not the intention of the Stamp Act. No, the Stamp Act does not void that transaction.
Mr. Banerjee, perhaps you would benefit by looking at your 5-page note.
Yes, my lord,
Because you omitted to present it.
I omitted to
But
write,
now,
therefore, my lord,
all
this
time
entire,
is being spent.
Yes, yes.
So perhaps
my lord, if
if
I
we
can
proceed,
place this note,
we
because
just have Mr. Banerjee.
my lord, I've addressed this very question.
Yes.
What my lord said, my lord, in fact, your lordship's example makes me, my lord, it has to be a little, maybe slightly tweaked. But my lord, I would submit that this covers the situation.
Let us have a look at this.
No, this was circulated.
You got that one?
This one.
This one underneath it. This is.
4, 5 page.
It will be inside. It might be inside.
And your lordships will have the act, the Stamp Act.
Not that, not.
Is given some.
Just. Just. Get a copy. Just. You have to have it. In the earlier. I'm so sorry. Give me a sec.
Mr. Bennett, you continue.
My lord, first page is section 11(6)(a) circumscribes the scope of authority of the appointing authority. My lord, that my lord, I have already placed that your lordships will not see. Please see section B, section 33 of the. Which one?
You got no.
Got it,
All you-
got it. My lord, we got one.
You got one.
इधर दे दी.
Another one?
That's one.
Yes, we can.
No.
दूसरा आपको 2 नहीं दीजिए अभी.
No, this is in the light of Justice Roy's example, my lord, of a standalone agreement and a agreement which has substantive, my lord, rights and obligations. In that light, please read. Stamp Act is a general provision which is a fiscal measure attracted by an instrument. Section 33(1) is titled Examination and Impounding of Instruments. So, my lord, examination necessarily must precede any impounding. Necessarily before an impounding agreement, the judicial authority, which includes an arbitrator, has to examine the instrument under 33(2) of the Stamp Act. So, your lordships will keep 33(1) and 33(2) together. Would your lordship just look at 33(1) and 33(2) along with this to understand this argument? 33(1) says every person having by law consent of parties. That one aspect, whether it covers a section 11 case. Authority to receive evidence. Every person in charge of public office except an officer of police before any instrument chargeable in his opinion with duty is produced or comes in the performance of his functions. Your lordship will pause here. Shall do what? If it appears to him that such instrument is not duly stamped, impound the same. So, my lord, he must impound the same, but it must be preceded by an examination that the instrument is not duly stamped. Now, please see 33(2). For that purpose, my lord, for the purpose of examination, every such person shall examine every instrument so chargeable and not so produced coming before in order to ascertain what is the scope of his examination, whether it is stamped with the stamp of the value and description required by the law in force in India when such instrument was executed or first executed. So, my lord, this is the examination he has to carry out. Now, please come to paragraph 4 of the note. if this examination is to be carried out by an appointing authority under 11.6a, that authority will not only have to determine whether the arbitration agreement duly stamped or not, he'll also have to determine whether the instrument which would include the substantive agreement is required to be duly stamped, because the entire agreement will have to be seen. Inquiry would necessarily involve the appointing authority adjudicating upon the substantive rights and obligations in the instruments, apart from determining who is liable for what amount. So, my lord, practically he will have to look at the entire document to determine and examine what is the stamp duty. Now, my lord, that I would respectfully submit that the 33.2 examination necessarily be wider in scope than the limited examination of existence of arbitration agreement enjoined by 11.6a. So, my lord, my submission is that please see 33.2. 33.2 is prior to impounding. If you have to impound, you have to look at the entirety of the document. My lord, I am only one caveat following from Justice Roy's, my lord, example. Supposing it is just an arbitration agreement, which is 2 pages, my lord. Actually, frankly, my lord, no such document comes on record, because that's 5,500 rupees. So that will be, my lord, it will not really arise. Every document which you are now going to impound will require a wide-ranging examination. And that wide-ranging examination will not be limited to, my lord, 11.6a is confined. That's the first word. Examination, same word in, my lord, 6a and 33.2. Existence, which we are debating, my lord, what existence mean? I don't want to interrupt, my lord, I have something to say, of the arbitration agreement. So, my lord,
Mr. Banerjee, why are you saying the scope of examination would have to be widened?
for this reason, my lord,
Because
the scope,
at the 11.6 stage,
right,
court will look only on the basis of the presumption that there are 2 agreements, not presumption, that is the fact. There's one agreement for execution of contract or whatever, the other is for arbitration. For 11.6, court will have to look at only the existence of arbitration
Correct.
agreement and whether.
But, my lord, at the same time, if we say that the 11.6 court has to examine for the purpose of stamping, the court will then necessarily have to look at arbitration agreement plus substantive agreement, because the document instrument, my lord, now my learned friend insists that the instrument is one, my lord. I also concede instrument is one.
You are expanding the scope.
Now, my lord, if the instrument is one, you necessarily, if you have to check whether it is duly stamped or not, which you have to do before you impound. Step 1 is examination. Step 2 is instrument is unduly is insufficiently stamped. Step 3, impound. So, my lord, I am saying that step 1 examination in 11.6 will be wider if you are to operate 33.2. And without 33.2, you cannot operate 33.1. Now, my lord, in the balance of the note, if your lordship sees,
The legislature
But use the law commission report that,
Sorry, one.
produced that law commission report which led to 6A.
see, yes, my lord, I have read 5 paragraphs.
That's right. This is, I mean, like, is it part of the document?
It's, my lord, yes, it is quoted, my lord. It's in the compilation volume 4.
Wanted to overrule SPB.
Yes, I have shown those 7, 8, 10 paragraphs. But here, my lord, in this note, I have quoted, my lord, para 29. Please see para 29. According to me, para 29 in this very note is relevant. The Supreme Court has had occasion to deliberate on scope and nature, so and so. Unfortunately, however, the question before Supreme Court, framed in terms of whether power is judicial or administrative, which obfuscates the real issue underlying such nomenclature as to 1. The scope of such power, i.e., the scope of arguments which a court will consider while deciding whether to appoint an arbitrator or not. Well, Lord, i.e., whether arbitration exists, null and void, whether it's voidable, which of these it should leave for decisions of arbitration. So, my lord, the scope of the arguments have been limited. So,
report is in which document?
my lord, volume 4, page 1.
Volume 4.
We have put in, my lord, the entirety of the report. There are 8 or 12 paragraphs, my lord. In my note, I have mentioned them.
To you also the question that, you know, ordinary principle is that the parliament is aware of the existing law.
Right, my lord.
They were aware of the Stamp Act. And what they were trying to get rid of through the insertion of 6A was something different. They have always presumed that
My lord,
back is there.
my lord, that's the question.
Unless we say that Parliament didn't sort
My lord,
of
Parliament,
eclipse the 6A, I mean the stamp act.
my lord, I am not saying Parliament has eclipsed the Stamp Act. My lord, I am saying that
Postponing it to the.
yes, I'm not saying that, my lord. I'm only saying that if you want to give, if, my lord, the legislative intent is to limit the scope of argument. You know, the phrase used in the parliamentary report, the Law Commission report, please limit the scope of the argument.
That's right. That is in the context of certain other questions
My lord,
which have been gone into by the court.
my lord, so the
Do you
question.
think that Parliament intended that section 33, 35 should become dead letter?
My lord, I am not saying that, my lord. For a moment, I am not saying it becomes a dead letter, my lord. I am only saying that a reasonable and rational reading of 11(6)(a), 33 and 35 means that this issue of stamping is to be raised before the arbitrator, who is fully empowered. My lord, I have got detailed guidelines on that. Your lordships wanted some guidelines.
One question, section 33, otherwise you would agree does apply.
My lord, 33, if dehors 11(6)(a), my lord.
Authority to, you want that question, authority to receive evidence.
My lord, I had a look at that. We had also a debate internally about that. We could not find any judgment on, my lord. 11 and authority.
What's your submission otherwise? But for this view which you are canvassing,
My lord,
would it be a case of authority to?
my lord, there is another way of looking at it, my lord. What those judgments, my lord, one of my colleagues will present, my lord, that the Arbitration Act is a complete code, and therefore, my lord, the Stamp Act, to the extent, my lord, that there is any inconsistency, will not, my lord, increase the scope. My lord, there's Kandla judgment, etc. there.
So under section 20 of the earlier Arbitration Act, certainly it was a court and it was authority to receive evidence. It had to be proved. I mean, it had
My lord,
to be
under the 1940
40 Act.
40 Act, my lord.
What you're asking is, having.
I'll come back on that. My lord, I could not find any case. We also had this debate.
But what is your submission then? Whether otherwise section 33 would apply, because that is the beginning, starting point of all discussion.
My lord, 33, my lord, I would then have to
Mr.
say,
Banerjee, can you just put it across in this fashion? Just to take it forward, what my brother Justice Joseph is saying. If the power to impound and arrange for levy of the stamp duty is at the stage of the arbiter or the tribunal,
correct, my lord.
the objective of the Stamp Act still gets protected.
It's fully-
It doesn't get.
It's fully protected.
So the argument that is being, counter argument that is being advanced, that you are defeating the provisions of the Stamp Act, can always be protected at the stage of the arbitrator
Correct.
also.
That's the
I think you can also put it in that fashion.
That's my lord. Insofar as the impact of 33 is concerned, my lord, 33 when it was brought out in 1899, my lord, nobody and the 1899 Arbitration Act, my lord, permitted an oral arbitration also. So, my lord, there was no contempt. It's a general statute, my lord. It's a general statute, and we are now, my lord, treating 11(6)(a) as a full-fledged court, my lord. Our, my lord, problem here is because the word court and high court has been used, my lord, that we are having all these, my lord. The other point I wanted to make, my lord, is court under 2(1)(e), which is the court which adjudicates matters, my lord. Your lordship will see Section 11, High Court or Supreme Court does not fall within that. So, my lord, it is not a court in the sense of 2(1)(e), and perhaps, my lord, then if I am pushed to the wall, I will say, my lord, that 33(1) will not trigger. We could not find any case on this, but certainly, my lord, it is not a full-fledged court in the sense that
Authority to receive evidence.
with
It
that.
not be a court.
It's not, my lord, 2(1)(e) court will be such a court which has authority to receive evidence.
Whether the High Court and Supreme Court acting under section
11, my lord.
is an authority to receive.
My lord, it is not, it is, my lord, I would say no, my lord, because I would contrast it with 2(1)(e) and say that,
What about 2(1)(e)? I mean, don't bring in 2(1)(e).
my lord, there is a distinction in the act. So I'm only using that to say
The
that,
nature of the proceeding under section 11 would it be rendering, render the Supreme Court and the High Court not authorities competent to, I told you, there are two ways of interpreting it.
Please.
One is Supreme Court. and High Court,
All, my lord, just because it is the Supreme Court, it is competent to
it
receive.
has authority to receive evidence. That is one way of looking at it. In the present proceeding under Section 11.
Manoj, I would say no, but I will get some material to justify that. Manoj, I would say no, but I will get some material to justify that. I don't want to interrupt, Manoj, my.
Because when the arbitration agreement is produced as part of the Section 11 petition, is it receiving
Is it
evidence?
not? It is not a formal, my lord.
Receiving evidence. This is what, because
It is
goes
not
to rules
formally,
matter.
my lord, admitting into evidence.
Huh?
It is not a formal admitting into evidence as understood under the
Receiving in evidence,
Manoj,
admitting in evidence.
admitting in evidence, my lord,
Receiving is prelude to admitting.
is a prelude.
Only authority which can receive in evidence can admit evidence. Section
So, Manoj,
33 is followed by.
Right. Admission, Manoj, this is not a case where. Manoj,
Because the predecessor is inbound it, then penalty is paid,
admitted. So, Manoj, that stage,
because ordinarily you produce it in order 13.
Right.
The
and Manoj, that we have,
documents are produced.
and Manoj, then 11 also is really in some sense, a prima facie finding also. It's not really a determinative final.
Ordinarily in a civil court, when the list of documents are produced, the munsif or the civil judge, senior, whoever it is, at the very first stage, he may refer it. He doesn't have to wait till the evidence is
Correct.
in a normal civil trial.
Manoj, I'll come back on this and I'll show Manoj the guide. There are some guidelines we formulated and reformed. I'll come back on it. Manoj, only this I wanted to point out because I already
Yes,
tendered.
we understood. Let them continue. Yes. Now you have the benefit of listening to him also. You can answer what you have to say by way of his interpretation. That if you have to examine it, subsection 2 of 33(2), it is not in an inexorable rule that whenever it is produced, you have to apply your mind and then impound it. You can put it off to the next stage if sort of close your eyes a little bit and then allow it to pass muster, look whether it exists both in law and on facts. One way of looking at it.
Only postponing.
Manoj, the examination is
No,
wider.
Saying that get through quickly Section
That's what-
7
you are
because
only
the 30 days, my brother says, could also be present in our mind.
You're just postponing the operation. Most. Postponing 33 and 35 to the arbitrator.
That's it.
Minutes, may I endeavor to place the stamp act, minutes, perhaps to show minutes that it is not such a complicated adjudication which is sought to be done. I will not repeat minutes, section 2, section 3. I will show section 17. First,
Nobody is saying there's no scope of adjudication. It has to be. Because once we are of the unanimity, subject to what others may say, that it has to be stamped. So the ruling out this judgment before us says no, not to be stamped. And global. We prima facie have our own reservation about it. So if it has to be stamped,
it has to be.
then that stage over. Now the only thing is this examination which has to be made over the document in question as to whether it is adequately stamped or insufficiently stamped or unstamped. At what stage? That is the only question. If it is pre-reference, the thing is 6A. If post-reference, this task will be taken care of by the arbitrator and the party to proceed. That is only examination. So 33 is the examination, subsection 2, the examination and then impounding on the state. If not stamped, then 35 is there. We are asking you, you are saying no, presuppose first no. The very threshold, you have to hold this examination and a scrutiny to the document and to be adequately stamped by a collector or by own, whatever you do it, and then proceed. This is what to say.
This is what I want to say this much. To understand this much, let us examine first how the Stamp Act goes about adjudication and stamping. How fast is the mechanism if you really want to be fast?
Oh, you can't educate all our officers there.
No, I'm not on that. May I request your lordship to see the Stamp Act? few sections to show the working of the Stamp Act. That nothing stalls. If you don't want it to stall, nothing stalls. Nothing. Please have section 17. What is the trigger? Section 17, Stamp Act.
Trigger, you raise an objection, the trigger there. Any party who was not expressed it for arbitration, raise an objection and the trigger comes.
Because I'm saying trigger for the purpose of stamping. And what is the adjudicatory mechanism there? Section 70. Instruments executed in India. All instruments chargeable with duty and executed by any person in India shall be stamped before or at the time of execution. Now, if we see the definition of execution, it is signature. That is section 2, subsection 12. Simple signature. So at the time or before, you have to pay stamp duty. 18. If it is outside India, then the 1 month becomes 3 months after it is received in India. So before or at the time. Now please have section 27. What are the contents? Facts affecting duty to be set forth in instrument. The consideration, if any, and all other facts and circumstances affecting the chargeability of any instrument with duty or the amount of the duty with which it is chargeable shall be fully and truly set forth therein. Then please have 29. Who pays duty? In absence of an agreement to the contrary, the expense of providing proper stamp shall be borne. The lordships may have A, then if a person executes, then D. If a person takes a contract, then D, A, B, C, D are there. So liability also is fixed. Your payment, time of payment, your person who is responsible, then please have 31. Where an instrument, so mark these words, whether executed or not. So even before you've signed it, you can send a draft. And whether previously stamped or not is brought to the collector, and the person bringing it applies to have the opinion of that officer as to the duty, if any, with which it is chargeable, and pays a fee of such amount not exceeding 5 rupees and not less than 59 paise, as the collector may in each case direct. The collector shall determine the duty, if any, with which in his judgment the instrument is chargeable. So
14 also. 14 also. Because only one instrument to be on the same stamp.
yes, I'm so
If you are
single
saying
document.
that the arbitration agreement, it is another, and the other thing, it is separate, that is not permissible in view of this. What is to be looked into is the instrument. Please read about whether it is relevant, just 14.
Yes, 49. Only one instrument to be on same stamp. No second instrument chargeable with duty shall be written upon a piece of stamped paper upon which an instrument chargeable with duty has already been written, provided that nothing in this section shall prevent any endorsement which is duly stamped or is not chargeable with duty being made upon any instrument for the purpose of transferring any right created or evidence thereby, or of acknowledging the receipt of any money or goods, the payment or delivery of which is secured thereby. Coming back to section 31. So even before you execute, you sign the document, you can send it to the collector for opinion. Now on getting it, what does the collector do? For this purpose, the collector may require to be furnished with an abstract of the instrument and also with such affidavit or other evidence as he may deem necessary to prove that all the facts and circumstances affecting the chargeability of the instrument with duty or the amount of the duty which it is chargeable are fully and truly set forth therein, and may refuse to proceed upon such application until such abstract and evidence has been furnished accordingly. Even before
We are not examining the very scheme of the Act of Stamp Act. We are on a very limited issue.
may I submit?
Come back to the issue in question to us as to what, whether pre or post, and why pre.
Let's the issue what I can guess. It is a time consuming. It takes time.
Time consuming is something different.
And it will require
Let's go into practical aspect.
11.6a means that's what I'm saying. The instrument, the Stamp Act provides stages at which who is to pay, what is to pay. Schedule has, if this is the document, this is the amount. That is what it is adjudication. If this is the document, this is what the purpose to do as per schedule, this is the stamp duty. Simple. Who is responsible to pay? 29 will apply. You are not sure if stamp duty is payable is correct, please take a draft to the collector. Once he endorses it, pay stamp duty, use it. There is no bar. 32 minutes also, once it is done, the bar, there is no bar. The endorsement works. It is all that has been provided to you. If you fail to do it, then 33 comes in. Therefore, minutes to say that it would consume time, which in my respectful submission, you had an opportunity in section 17, even before signing it, minutes, you can take an opinion of the collector. That can be done. You don't do it. You don't pay or pay it insufficient. And then when the bar starts applying a 33 and because you tender it in a court of law, then minutes, can you say that the purpose of 11.6a would be defeated? You had opportunities. And this is not all. Please have page section 44. Person A is responsible, person B pays. He can collect it, make it part of his claim. Person paying duty or penalty may recover the same in certain cases. When any duty or penalty has been paid under section 35, section 37, section 40, 41 by any person in respect of an instrument and by agreement or under the provisions of section 29 or any other enactment in force at the time when such instrument was executed, such other person was bound to bear the expense of providing the proper stamp of such instrument. The first mentioned person shall be entitled to recover from such person the amount of stamp, the amount of duty or penalty so paid. Skip 2. Such amount may, if the court thinks fit, be included in any order as to costs in any suit or proceeding to which such persons are parties and in which such instrument has been tendered in evidence. If the court does not include the amount in such order, no further proceedings for recovery of the amount shall be maintained. Now see 45. Power of Revenue Authority to refund penalty or excess duty in certain cases. Where any penalty is paid under section 35 or section 40, the Chief Revenue Controlling Authority may, upon application in writing made within 1 year from the date of payment, refund such penalty wholly or in part. Then 2 also, refund of stamp duty. Now please have the educated mechanism.
One moment, perhaps something. You have a scheme framed under section 11. Right? So kindly look at the appointment of arbitrators by the Chief Justice of India scheme 1996. That is still available?
Yes.
Still relevant? Can we see what is the nature of the proceeding and what is to accompany and what is the scheme? What does the scheme provide for? Is it there? Is it there? Let's see. This is the page 65. This is to be followed, isn't it? You take it that this is still relevant?
Yes, ma'am.
Kindly go through it. This is only 2 pages.
Yes, ma'am.
What is the
Request 2.
so this is a request to the Chief Justice. No, of course, it has been found to be a judicial proceeding, not administrative. But so it starts with a request and let's see the very first thing that is to accompany the request.
The request to the Chief Justice under subsection 4 or 5 or 6 of section 11 shall be made in writing and shall be accompanied by A. The original arbitration agreement or a duly certified copy thereof. The names and addresses of the parties to the arbitration agreement, the names and addresses of the arbitrators, if any, already appointed, the name and address of the person or institution, if any, to whom or by which any function has been entrusted by the parties to the arbitration agreement under the appointment procedure agreed upon by them, the qualifications required, if any, of the arbitrators by the agreement of the parties, a brief written statement describing the general nature of dispute and the points at issue, the relief or remedy sought, and an affidavit supported by relevant document to the effect that the condition to be satisfied under subsection 4, 5 or 6 of section 11, as the case may be, before making the request to the Chief Justice has been satisfied. And 5 additional terms.
And then it says rejection of request under section 6.
6. Where the request made by any party does not fulfill the requirements of para 2 of this scheme, the Chief Justice or the person or the institution designated by him may reject it.
Yes. So this is a statutory scheme
Scheme.
framed under the Act. We are just again interlinking it with the first sentence of section 33,
Person receiving evidence.
evidence. Because it is H, section 2H speaks about an affidavit
Right.
supported by the relevant document to the effect that the condition under section 4 and 5 has been satisfied. So let us have a look at section
Section
4,
11,
subsection
4,
4 and 5.
4, 5 are those provisions. Affidavit has to say that I have not followed the procedure. That's the limited portion of the affidavit. It's not.
So this document, what you are again straining to come back to, this document, is it being received in evidence?
My information, it is being received as evidence of an arbitration agreement or appointment of an arbitrator. Otherwise, because there is no point in filing this
Because you
document
will see one more thing. You can either produce the original
and the certified copy.
or a certified copy. Okay.
The original will have to be stamped. The certified copy also will have to be stamped. Either way.
Supposing the certified copy is produced
Yes.
and it is let into evidence under section 36.
Because 36 supposes that it has already come into evidence.
Ah.
It has already been acted upon. Then 36 comes. That
Supposing it is let into evidence without any objection and the court not looking into it. Will it then be evidence? And can you still say that you will not act upon it?
because there are judgments which are based if the lordship wants.
No, once it is let into evidence, though it is not stamped or insufficiently stamped, can the court refuse at the end of the day when the judgment is pronounced to not treat it as evidence and say we will not
Because
act
your
upon it?
foundation is missing.
No. Once it is let into evidence, the law says that forget about the fact
Then
that it is
everything,
not
then
stamped.
it
Then it becomes evidence.
becomes evidence.
Then you cannot say we will ignore it.
Which 36 provides once it is admitted, then such admission shall not, unless 61 shall be called into question. That is the precision. Now means
61-2. 61.
plus before
61-2.
Oh yes, 61.
Instrument should not have been admitted in evidence without
Yes.
payment of duty. Then what should be? A declaration.
If such instrument, if such court, after such consideration is of the opinion that such instrument should not have been admitted in evidence without the payment of duty and penalty under section 36 or without the payment of a higher duty and penalty than those paid, it may record a declaration to that effect and determine the amount of duty with which such instrument is chargeable and may require any person in whose possession of power such instrument is to produce the same and may impound the same when produced. And this is given to a higher court.
Yes.
And this is done on application of either suo motu or on application of the collector. 61(1) says, please, 61(1). When any court in exercise of its civil or revenue jurisdiction or any criminal court in any proceeding under chapter 12 or chapter 26 of the CRPC 1898 makes any order admitting any instrument in evidence as duly stamped or as not requiring a stamp or upon payment of duty and penalty under section 35, the court to which appeal lies from or references are made by such first pension court may, of its own motion or on the application of the collector, take such order into consideration. Then 2 applies.
Yes.
Now, chapter 6 verse first is the control of the Chief Revenue Control Authority. If the collector has any doubts, he can refer it to the Chief Revenue. If he has any doubts, statement of case to the Honorable High Court.
Yeah.
So a very systematic procedure has been laid down. Then, beloveds, may I invite your Lordship's attention to certain stamp acts of 3 foreign countries. The bar of section 35 is also there in the stamp acts of these foreign countries. And those are arbitration heavens, allegedly. Let's just have the first, your Lordships may take volume 3, Convenience compilation 3, page 260. This is belongs to UK Stamp Act. Lordships may have page 261. Convenience compilation 3, page 261, UK Stamp Act. Please have page 261, bottom, section 14.
Spending average.
Convenience compilation 3 by Atul.
This is Gaurav Banerjee, the other one.
Mr. Goel.
You want to
Mr. Goel.
spending.
You don't see of Mr. Goel.
Manoj, this is Roy.
Yeah, I'm with you. But what is the purpose of showing us the stamp act
Look,
of UK?
I will show stamp acts of 3 countries, which have a similar provision. And this includes UK, Singapore, Malaysia. Terms upon which instruments not duly stamped may be received in evidence. Upon the production of an instrument chargeable with any duty, as evidence in any court of civil judicature in any part of the United Kingdom, or before any arbitrator or referee, notice shall be taken by the judge, arbitrator, or referee of any omission or insufficiency of the stamp thereon, and the instrument may, on payment to the officer of the court, whose duty it is to read the instrument, or to the arbitrator or referee, of the amount of the unpaid duty and any interest or penalty payable on stamping the same, and of a further sum of £1 be received in evidence, saving all just exceptions on other grounds. So this is proviso A, 35. Now just have 4. Save as aforesaid, an instrument executed in any part of the United Kingdom or relating wheresoever executed to any property situate or to any matter or thing done or to be done in any part of the United Kingdom shall not, except in criminal proceedings, be given in evidence or be available for any purpose whatever, unless it is duly stamped in accordance with the law in force at the time when it was executed. Then Miller's may have Singapore. The next page, 264. Relevant section, Miller's, is 268. At page 268, section 51 and 52, identical to our sections. 268, section 51 top. Every person having by law or consent of the parties authority to receive evidence, and every public officer or officer of a statutory body before whom any instrument chargeable in his or her opinion with duty is produced or comes in the performance of his or her functions must, if it appears to him or her that such instrument is not duly stamped, impound the same. For the purpose of such subsection 1, every such person must examine every instrument so chargeable and so produced or coming before the person in order to ascertain whether it is stamped with a stamp of the value and description required by the laws in force in Singapore when such instrument was executed or first executed. Then 3, it does not apply to large police officer and so and so. Just have 52 again. Subject to this section, an instrument chargeable with duty must not be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive evidence and must not be acted upon, registered or authenticated by any such person or by any police officer unless the instrument is duly stamped. Singapore. Now, Your Lordships may have Malaysia. These are all the three arbitration heavens. Same Stamp Act provisions impounding paid duty. 272. This is the Malaysia law. 51. Every person having by law of consent of parties authority to receive evidence, and every person in charge of a public office, except an officer of police, before whom any instrument chargeable in his opinion with duty is produced or comes in the performance of his functions shall, if it appears to him that such instrument is not duly stamped, impound the same. Then 52. Again, no instrument chargeable with duty shall.
We are not examining the constitutional validity of any provision of the Stamp Act here. We are not examining.
Yes.
So the comparison of other countries, Stamp Act not required. Our Stamp Act is very clear. There is no doubt of ambiguity there. We only examining in totality what should be a stage where the trigger of stamping should be taken care of in the mechanism for arbitration only.
Section of duty. That
Yes.
can be done at-
Keeping the revenue, there should be no revenue loss. Where the trigger should come. So the term confined to examine the arbitration agreement under
Existence.
Existence.
Section 8.
No, in section 6A, subsection 6A.
6A.
Existence of an arbitration agreement. Confined to examine the existence of an arbitration agreement. That is the term.
Let us fall back to the state.
Now the only thing is what we are dilating on the issue is whether this trigger of unstamped or insufficient stamped is to be looked into at this stage or it has to be
Left to the arbitrator.
post reference stage.
In fact, that your lordships have already answered in Gangappa. It applies to every authority, float, and the legislative scheme doesn't cut it across. It applies to the court, it applies to the arbitrators. So,
Yeah.
if we read this section as it stands, please, 33, 35, I have shown from the provisions of the Stamp Act that a person, an applicant who is relying on an arbitration agreement for the purpose of section 8, 9, 11, he has had ample amount of opportunity to pay stamp duty.
And one thing more.
1. 2.
Once you are enclosing this agreement at the pre-reference stage, is a document or an evidence?
It is the instrument was given as an evidence of an arbitration agreement. It is an evidence because under section 8, you're asking the honorable court to act upon the arbitration
Agreement is in the form of a document on the
It
court.
is in writing.
Maybe writing. Document is always in writing.
Yes,
But whether it is an evidence,
it is an evidence of an arbitration agreement. You are receiving the document as an evidence of an arbitration agreement. Let's A under section 8, refer the parties, section 9 for interim relief, section 11, 6A to appoint an arbitrator. Let's, you cannot, in my deepest, in my respectful submission, Millards, you file a document before the court saying in section 8, 9, 11 that this is the arbitration agreement between us. What is the party doing? Is it not relying on the instrument, the document, as evidence of its contention that there is an arbitration agreement? Or the inquiry under 6A, if we put it this way, is it limited to only saying whether it is printed or not? Is this the inquiry contemplated? Then why have?
it must be signed by the parties. There must be a clause of arbitration. Prima facie, the arbitral dispute must be within the parameters in the corners of the agreement.
Public policy also. Some disputes will not be arbitrable.
And pre-6A, it was a judicial orders.
Yes, limitation also used to be.
That's correct, but post-6A, would it be judicial order?
Submission, it would be a judicial order.
Tell us.
It would be a.
Pre-6A, obviously, constituent say judicial order. Post-6A is the judicial order. Once your jurisdiction is makes so limited within the brackets, is it a judicial order?
Confined.
If a judicial order, you have to master all conditions, preconditions, which have been confined in 6A. So whether the 6, you see, my judgment, which I was the author earlier, to rule, my view that time was only this, that as long as the court, which he said, to change the mindset, is exercising the power as a judicial exercise of power, then it must have some reasoning, some scope to examine and to record satisfaction. But after 6A, the scope has been limited down. It's coming to an extent only to examine, confine the agreement and proceed further. So that the time schedule, as legislation wisdom thought, must be confined and go ahead. If we again go back to system, pre-6A, then we are restoring back the same view earlier.
Right, I understand. 6A, because the Law Commission's report your Lordships have seen, only three judgments. The SBP and Bogara. Only they were dealt with. Had stamping been a part of the contemplation of the legislature, it would have said SMST also. SMST, legislature.
That we have some, merely because the Law Commission's report has not referred a judgment, that doesn't mean that the judgment stands.
Let us examine it.
They take totality of the view in expressing themselves why they are asking for amendment. But merely because one judgment of this court
Is not referred to.
remain unnoticed or remain unnoticed, it can't give an impression that no, the judgment still holds. You have to examine the statutory amendment made in the light of whatever the observation.
We are now going back to the pre-SBP that it is only an administrative power. Just look at it, close your eyes and then send it to the arbitrator. Then it gets stalled before the arbitrator because of the stamp act.
You can't be look at it and close your eyes. You will be opening your eyes, look at it, and then thereafter.
That's what I'm saying. You close your eyes to the illegality.
No,
This is not impounding,
it's
cannot
not
happen.
illegality.
Can't be done.
If recovery is possible at a deferred stage, then you are not defeating the stamp act. We must be conscious at all time of that particular possibility. At the time of scrutiny under 11, yes, you look into whether it exists or not. So far as recovery of stamp duty is concerned, that is possible even at the deferred stage, that you can't run away from. So you have to look at it with open eye and maybe also be conscious that with this open eye, am I also keeping in mind that recovery of stamp duty would be possible at a deferred stage?
Therefore, this, I'm repeating.
If the judge under 11(6), it holds that the arbitration agreement exists, can that question be revisited in section 16?
That was been dealt with and then said, prima facie, existence is there, and then the final call would be taken by the arbitrator. That
No. Let's get that straight. Come to paragraph 12 of SBP and then read paragraph 33 of the Law Commission report. Let's understand it.
My lord may see the judgment of Justice Nariman on this point,
That's right. No, we'll see that. But
where he
before
says
that-
prima facie existence, and then existence will go in trial, my lord, before the arbitrator. I'll just show existence, my lord, specifically. That's that.
No, just the,
Para.
you read page 644 with it, of this 2005 SCC, the SPP person.
No, because section 16(6) take note of
Existence. My lord,
Yes.
that was the real reason for, my lord, the amendment. That was the real reason.
That
My
was,
lord,
yeah, if you just read.
No, that is the majority.
Paragraph 12 at page 644.
was
my lord, that is the majority view which has now not been accepted.
Let us see. Let us go step by step. Just read page 644 of SBP.
Take out the book.
Yes, may I please it?
Yeah.
Section 16 of the Act.
Just a minute.
Sorry.
That's 360. It was 360. Say it was to overrule that. It has been done. What part of it has been overruled? We have to. I'll just show that. Paragraph
Paragraph 12,
12 at
643.
page 644.
644.
And towards the end of that paragraph 12, if you just say from D, Basicum D,
It also appears to us.
to us.
It also appears to us to be.
It also appears to us.
It also appears to us to be incongruous. I'm so sorry.
Yeah.
It also appears to us to be incongruous to say that after the Chief Justice had appointed an arbitral tribunal, the arbitral tribunal can turn around and say that the Chief Justice had no jurisdiction or authority to appoint the tribunal, the very creature brought into existence by the exercise of power by its creator, the Chief Justice. The argument of the learned senior counsel, Mr. K. Venugopal, that Section 16 has full play only when an arbitral tribunal is constituted without intervention under Section 11(6) of the Act is one way of reconciling that provision with Section 11 of the Act, especially in the context of subsection 7 thereof. We are inclined to the view that the decision of the Chief Justice on the issue of jurisdiction and the existence of a valid arbitration agreement would be binding on the parties where the matter goes to the tribunal and at subsequent stages of the proceeding, except in an appeal to the Supreme Court in the case of a decision being by the Chief Justice of the High Court or by a judge of the High Court designated by him.
So this is what was laid down.
Earlier view.
Now you come to paragraph 30 of the Law Commission report.
Here also in paragraph 15,
Paragraph
the
30.
same judgment paragraph 15 is also there.
Yes.
646.
Normally, a person or designator cannot delegate his power to another. Here, the Chief Justice of the High Court or the Chief Justice.
That's a different issue.
And exercise of power, judicial power it is stated.
And judicial power, and that has been. So now we come to paragraph 30 of the Law Commission report.
Yes.
That is convenience volume 4. By the amicus curiae. Let's go through this paragraph 30 and convenience volume 4.
Not all this has been considered, my lord, in Vidya Drolia and then Praveen Electrical.
That's right. Now we
This
are in a,
very portion, my lord.
that's right. Since we are now in a larger.
Yes, my lord, because then what will happen is,
No, we'd like to see.
right, I'll show, my lord, Praveen Electricals on this point also.
Absolutely. We want to know what really the Law Commission had in mind. And paragraph 30.
30.
You got that, Commissioner?
Yes, page 26. After the city. I'm sorry.
That's the law.
After a series culminating in the decisions in SBP versus Patel Engineering, the Supreme Court held that the power to appoint an arbitrator under Section 11 is a judicial power. The underlying issues in this judgment relating to the scope were subsequently clarified by Ravindran J. in National Insurance versus Bogara Polyfab, where the Supreme Court laid down as follows. 1. The issues first category, which the Chief Justice, his designate, will have to decide are A. Whether the party making the application has approached the appropriate record. B. Whether there is an arbitration agreement and where the party who has applied under Section 11 of the Act is a party to such agreement. 2. The issues second category, which the Chief Justice and his designate may choose to decide are A. Whether the claim is a dead, long-barred claim or a live claim. B. Whether the parties have concluded the contract transaction by recording satisfaction of their mutual rights and obligation or by receiving the final payment without objection. The issues third category, which the Chief Justice, his designate, should leave exclusively to the arbitral tribunal are whether a claim falls within the arbitration clause, as for example, a matter which is reserved for final decision of a departmental authority and accepted or excluded from arbitration. B. Merits of any claim involved in the arbitration. The Commission is of the view that in this context, the same test regarding scope and nature of judicial intervention as applicable in the context of Section 11.
So pause for a moment. The Commission also accepted that the nature of the proceeding is judicial. Law Commission also proceeds that it is to that extent the full constitution bill is accepted.
Is accepted.
Now you read para 33. That's all.
33.
Para 33. This is where you get the.
It is in this context, the Commission has recommended amendments to Section 8 and 11 of the Arbitration and Conciliation Act 1996. The scope of judicial intervention is only restricted to situations where the court, judicial authority, finds that the arbitration agreement does not exist or is null and void. So far as the nature of intervention is concerned, it is recommended that in the event the court or judicial authority is prima facie satisfied against the argument challenging the arbitration agreement, it shall appoint the arbitrator and or refer the parties to arbitration as the case may be. The amendment envisages that the judicial authority shall not refer the parties to arbitration only if it finds that there does not exist an arbitration agreement or that it is null and void. If the judicial authority is of the opinion that prima facie the arbitration agreement exists, then it shall refer the dispute to arbitration and leave the existence of the arbitration agreement to be finally determined by the arbitral
So
tribunal.
this is the kind of, this is a report. So what we are trying to impress upon you and Leonard and Mike is the issues which actually were generated in SBP and then in Bogara, various issues which could form subject matter of adjudication, none of it had to do with the standard. The mischief which was sought to be got over by insertion of 6C, confining yourself to the existence of an arbitration agreement, has nothing to do with the play of the standback. So the legislature was not concerned at all.
With stamp.
Standback would operate inexorably on its own.
What was, and if I may put it very simply, is the scope was expanded, it was reduced.
It was reduced to this.
Neither the SBP nor Boghara Millets were cases under the stamp. Even millets, if we go to Praveen Electricals, Mayavati Trading,
When he said the mischief rule, the mischief was
something
they wanted to reduce to
The
the
scope.
irreducible minimum the judicial scrutiny.
and the stamp back millets had been a private problem. It would have perhaps been, but stamping also will go. Will not be done.
One doubt that is passing through the mind. Suppose going by 6A,
6A.
that power can be exercised either by the Supreme Court or by the High Court. That's the case.
Yes, you want.
And suppose the High Court passes an order
Yes.
in exercise of this power and arriving at a passing an order, by an order. And if that order is passed by the High Court,
Yes.
whether that can be challenged before the Supreme Court. And if so, whether it should be treated as a judicial order or an order otherwise.
Was in my respectful submission first.
Because we will have to decide at that point of time what exactly is the nature
Correct.
of the order passed by the High Court in exercise of the power under 6A.
Right.
6A. So whether it is judicial or
Because in my,
Judicial order.
that is what that
in
is
my
what.
respectful submission, it would be a judicial.
It's a judicial order.
That is
because
what-
that's
First, number
clarified. It's very
So
clear.
it can only be a judicial order.
It can.
That is why.
Now let's,
Because if it is a judicial order,
if you're also.
Judicial order without judicial mind.
Unfortunately, this is what is sought to be.
See, order is judicial, but without judicial mind.
We don't.
If you ask judicial mind, then the court has to examine at least a prima facie all ingredients. But now 6 says no, don't do it.
Because then, if I may just ask, if this is the level of scrutiny demanded, why have
It's a judicial order. It's a
This honorable court do it?
No, judicial order confined to only the existence of the arbitration agreement. That is all that has been done.
Yes, if we are.
You have to reconcile both.
Banerjee is right in saying that you have to change your first mindset. Sitting in a court and deciding section 11, 6A application doesn't mean that you are passing a judicial application of mind. Don't do it.
No. What happened was the earlier view
We
was
agree.
even without issuing notice to the other side.
Several issues were being.
No, without issuing notice to the other side, only after hearing the person making the request, an order could be passed to make the appointment.
Yes.
So the constitution bench said that is wrong. So it is therefore, see, judicial mind, you have to hear the other side. The other side may point out to you that there is an insuperable obstacle, that there is really no arbitration agreement, valid agreement, and other things.
Right.
So then the parliament stepped in and said, confine yourself, judicial of course, you have to issue notice, you have to hear the other side, but you have to confine yourself to the existence of the agreement. This is all that has been done. Yes.
In my responsibility submission was just summing it up.
Yes.
Section 11, if you look at it, it's 11.6. If we are confining it to section 11.6, which in my submission, this is not. The nature of entrustment of power does not show that it is merely just seeing and referring. As my lords put it, there has to be a due application of mind. It must follow a process of rule of law, natural justice and everything. Now, let's to show or to say, Milos, that I will only, or one court can only see the existence and then leave it to the arbitrator, Milos, it is getting stalled at that stage. The arbitrator again cannot move ahead. As the court cannot move ahead, Milos, the same problem will be of the arbitrator, Milos. So, Milos, these are practical aspects, Milos, which I would submit. A court, Milos, would be in a better position to do rather than, Milos, leave it to the arbitrator. So, these are, Milos, on the stamp act, Milos. Now, Milos, may I have your attention, Milos, on the legal fiction aspect of the matter, because the entire basis of this judgment of NN Global is legal fiction. For that, Milos, may I invite your Lordship's attention to volume 2, convenience compilation 2, filed by me, Milos.
Wales.
Your compilation.
Yes, it comes straight to section 6, page 9, section 16.
इसमें माइक का स्टैंड इसको बैनर इसको इधर मेरे पास ये भी
Page 9, section 16, which creates that legal fiction and for what purpose? The separability of the arbitration agreement with the main contract. Because that's the foundation of NN Global. Please have page 9, section 16, competence of arbitral tribunal to rule on its jurisdiction. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement. And for that purpose, an arbitration agreement clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract. So first it states the purpose and then creates the fiction. The purpose of the fiction is to enable the tribunal to rule on its own jurisdiction, including with respect to the existence and validity. And the fiction is that the clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract. My expected submission was this is a legal fiction. Vidya Dhodia in para 126 holds that it is a legal fiction. Now, to extend this legal fiction to the Stamp Act and say that arbitration agreement can still be enforced if your main agreement is unstamped is a wrong extension of this legal fiction, which is not, in my submission, not permissible in law. I rely on 4 judgments, starting with Bengal immunity, same volume, page 66, relevant paragraph.
Complete your submission because
The submission
we
is
keep the clause A. It is very clear. It doesn't keep any doubt. An arbitration clause will form part of a contract. Shall be treated as an agreement independent of the other terms of the contract.
Yes.
So it becomes a standalone agreement. If there is a clause of arbitration in a contract, by virtue of section 16 subclause A, that also becomes a standalone agreement of arbitration,
it's the
regardless of the contractual terms and conditions. So what according to you is missing here?
No, it's not missing.
Yes.
My submission is that section 16, the separability doctrine,
Yes.
is a legal fiction.
That's correct.
Now, if it is a legal fiction, it is created for one specific purpose, that is to enable the tribunal to rule on its own jurisdiction as to validity and existence. This fiction, as done by R6 entirely, cannot extend to a Stamp Act and say, that since an arbitration agreement is a separate agreement which does not require stamping, and your main agreement requires stamping and does not being stamped, still the arbitration agreement can be enforced.
No, it has not been argued that arbitration agreement does not require stamping. What is being examined is at which stage that has to be tested, whether it has been stamped or not. Arbitration agreement will require stamping. I don't think there's any doubt on that.
Because I'm now coming to the basis of
You are on section 16 scope. You are arguing that arbitral tribunal may not choose to decide that.
No.
No,
My contention is 16 creates a legal fiction.
that's what the
Acceptability.
agreement arbitration agreement is
Doctrine-
separate. There is no.
The doctrine of separability, the concept of separability of the arbitration agreement with the main agreement is a legal fiction. Its use is for a specific purpose, and its extension to the Stamp Act of 1899 to hold that even though the main agreement is not stamped, still the arbitration agreement can be enforced is a wrong extension of the legal fiction. That's my submission. Because
That has not been argued here.
that is not, but that's the foundation of NN Global.
What was submission was that let the 11.6 court not look into this. Just because there's a writing that there shall be an arbitration clause,
NN
you will
Global,
look at that, then arbitral tribunal will decide whether it.
NN Global was not a case under 11.6a. Therefore, this was never the argument. The argument,
And then global only make a distinction that standalone arbitration agreement is not to be stamped. And that's why the doctrine of separability has been introduced. And they said the contract is to be stamped. You can continue with the proceedings on a
and even then makes section.
because contractual arbitration agreement is not to be stamped as per NN Global. So proceed further, and whatever the inquiries to be made in reference to unstamped contract, go ahead and complete the proceedings. This is what NN Global in substance say. But we all here the stamping is there. Stamping is there. But standalone agreement of arbitration by section of 16A and section 7. Section 7 say there should be independent agreement, arbitration agreement, contains so and so, so and so, so and so. Section 7 of the
Yes,
arbitration.
it was
And
either
then
part
16A
or
also says.
standalone.
Ultimately a standalone agreement. By either by fiction.
No. Section 7, when it talks of a standalone agreement, let's just see section 7.
Yes. It provides you
Two.
what content should be there.
Yes. An arbitration agreement may be in the form of an arbitration clause in a contract.
Yes.
Composite contract, two parts, main, your arbitration clause, or in the form of a separate agreement. Separate agreement means your first agreement is your complete agreement or main agreement, not having an arbitration clause at all. You have a separate page or separate instrument, document,
Like
which
ad-
contains
Like addendum.
addendum to an arbitration, to the main agreement. So it can be done in both ways. The NN Global Notes proceeds on the premise that just because it is separate by virtue of separability, that can be enforced despite the main instrument not being stamped. In my submission, this is not the extent to which the legal fiction.
If you're examining section 6A only, not further. We have to examine only the arbitral agreement,
Let's,
not the contract as such. Because we have, once if it's a standalone agreement, arbitration agreement, under 16A or 7, whatever you call it, then it is to be only, we are examining only this arbitration agreement.
there is some, the reference order of the
Yes.
matter under NN was,
That has to be changed. So penalty is right.
was not a matter under section 11.6a(1). 2.
Make no difference. Now the matter is referred to us.
Second, sir. The entire, if your lordships are right, see the arguments. No argument on this line was ever made in NN Global.
Forget
These
now.
are matters to be left at heart. What I'm trying to impress upon is your sections, your paragraph number 6 of the NN Global in its entirety, the other 6 to 6.11 are the operation of the separability principle to get over the bar of stamping. Now your lordships are examining at what stage stamping. Is it to be by the court at the threshold, or is it to be left to the arbitrator? My endeavor is to show that the legal fiction employed by section 16 is limited. It cannot go to section to the stamp, as has been done.
No, but why is this argument necessary?
Plus, this argument is necessary because
16 says clearly there are two agreements. Stamp Act says each instrument has to be stamped. So
either
the necessity of stamping is never in
doubt.
doubt. Whether at the 11.6 stage, if it is unstamped, court shall look into it or not, that is the question.
Ultimately, the instrument may have to be stamped.
It has to.
That's another thing. But the question is
Stage
whether there is any arbitral agreement is there or not. That is the entire the scope of the inquiry under examination under
The
1160.
question under exam. That's why I'm saying. The fundamental premise, and then global millers, let us accept para 7. Para 7, section 8, who will look into it? Section 8 order can be passed. In the meantime, parties can go. Section 9, it says interim order can be passed. In the meanwhile, it can go. Section 11, it cannot happen at all. You have to get it stamped. Because this means that operation of section 35 of the Stamp Act is now compartmentalized. It will not apply to 8, it will not apply to 9, but it will apply to 11. If one must looks at the reasoning, the entire para 7, in my simple submission was there is no reasoning why a selective application of section 35, where section 9, 8, as against section 11. Section 11, the court in fact holds that before you make an appointment, you get it stamped. Now, I invite your lordship's attention. Indian Global is also saying, before you do it, it is only in the section 8 and section 9 that it makes a distinction.
Please check once again.
Yes, please.
Otherwise, there is no application of reference.
Paragraph 7. 297.
Let us get. And global, as we have read over earlier.
B, page 298, B. Parties fail to make the appointment in accordance with the arbitration agreement, and an application is filed under section 11 before the court to invoke the.
Come to page 294. If you have the same
294, yes,
6.7
6.7.
and then SMS.
Yes. The Stamp Act is a fiscal enactment for payment of stamp duty to the state on certain classes of instruments specified in the Stamp Act. Section 40 of the Indian Stamp Act provides the procedure for instruments which have been impounded, and section 42 subsection 1 requires the instrument to be endorsed after it is duly stamped by the concerned collector. Section 42(2) provides that after the document is duly stamped, it shall be admissible in evidence and may be acted on. In our view, the decision in SMST Estates does not lay down the correct position of law on two issues. Roman 1, that an arbitration agreement in an unstamped commercial contract cannot be acted upon or is rendered unenforceable in law. Roman 2, that an arbitration agreement would be invalid where the contract or is voidable at the option of a party, such as under section 19 of the Indian Contract Act. We hold that since the arbitration agreement is an independent agreement between the parties and is not chargeable to payment of stamp duty, the non-payment of stamp duty on the commercial contract would not invalidate the arbitration clause or render it unenforceable, since it has an independent existence of its own. The view taken by the court on the issue of separability of the arbitration clause on the registration of the substantive contract ought to have been followed even with respect to the Stamp Act. The non-payment of stamp duty on the substantive contract would not invalidate even the main contract. It is a deficiency which is curable on the payment of requisite stamp duty.
So, they are proceeding on a premise that it is a separate agreement.
That's what I'm.
So, accordingly, not to be stamped, and the contract entered to the parties merely because it is unstamped agreement.
Main instrument
is unstamped, but because the doctrine of separability has been invoked, this becomes a standalone agreement for the purpose of arbitration. So it will not be invalid as long as it is unstamped. The contract is unstamped.
Yes.
This is what the global says. That's why we are asking you. We are examining in 60 only the agreement of arbitration. Arbitral agreement. We are examining the existence of an arbitration agreement. What we are examining is.
It is. It is. It is.
Yeah, I think we are not on the same page.
No, I am trying to just canvas that the entire premise of the entire para 6
Hmm.
is the doctrine of separability.
That's correct.
Correct. 1. 2. The doctrine of separability is now extended to say that even if the main instrument is not stamp, still the arbitration agreement contained in that main agreement can be enforced because it is separable.
That's correct. You're right.
Correct. Now, Millers, in my respectful submissions, this is an extension of a legal fiction, which is created by Section 16.
Correct.
This Stamp Act, the Arbitration and Conciliation Act. Now, Millers, if it is a legal fiction or it is a legal fiction, then it cannot be extended to a different statute. Because what we are trying to get over is a bar created by Section 35 of the Stamp Act. So a legal fiction which is created for a very specific purpose to enable the tribunal to rule on its own jurisdiction with respect to existence and validity is being stretched, and as a result of this, a bar created by Section 35 is being walked over.
Is it a fiction created under Section 16, or is it a recognition of a legal principle?
Let's,
The courts have always held that an arbitration agreement is a separate agreement.
it is.
So
This is
it's
a
not
step
as
in
if the
favor.
legislature is creating a fiction under Section 16.
Plus, this is a recognition of a fiction.
Recognition of a,
Statutory recognition of a fiction.
it's a recognition of a principle.
And Millers, I will show even the creators of this fiction, the English court Millers, have now restricted it that see it's a legal fiction, limited purpose. It does not insulate the arbitration agreement. I'll come to that UK judgment.
Complete what you according to limited purpose.
The limited purpose of the fiction is to enable Millers the tribunal. If you also just have the first opening sentence of Section 13, competence, competence, and separability. It is only that. It is only that. Nothing beyond that. The wording standards may rule on its own jurisdiction.
Yeah.
Because in volume case compilation, only 4 judgments. 2 first by the Bengal community was 11 judges, followed by a
The
constitutional.
limited purpose of a fiction.
Limited purpose. And one says it cannot extend to another act. Versus Bengal immunity, I will not read the entire judgment, just at page 66, para 52, or at page 66.
So it just,
I'll read it.
you don't have to, just give us a paragraph.
That is para number 52, page number 66, Bengal immunity.
It's citation also.
Yes, Milords. I'm so sorry. Just Milords, what I have filed, Milords, is 1955 to SCR 603, which is equal to AIR 1955 661. Then, Milords, I will show a Constitution bench, page 159 is, I'm not going to read, Milords, 2000, volume 2 SCC 699, the state of Maharashtra versus Lalji. Para 6, if your lordships don't mind, I would like to read this only.
699.
699, paragraph number 6. At page number 164. I'll just read it because this is what I want to show.
What are the other two?
I'll come to it. It is a well-known principle of construction that in interpreting a provision, creating a legal fiction, the court is to ascertain for what purpose the fiction is created, and after ascertaining this, the court is to assume all those facts and consequences which are incidental or inevitable for the case to giving effect to that fiction. But in so construing the fiction, it is not to be extended beyond the purpose for which it is created or beyond the language of the section by which it is created. A legal fiction, in terms enacted for the purpose of one act, is normally restricted to that act and cannot be extended to cover another act. There's this note. Then the lordships may have another Constitution bench. It is 2005, volume 1 SCC 754. The relevant paragraph is paragraph number 39. Same, Milords, legal fiction. Restricted. Now, Milords, I would show 2 judgments under the Arbitration Act. There is a legal fiction created by Section 17(2), interim order passed by an arbitrator. It is deemed to be an order passed by a court, therefore enforceable. Similarly, Section 36, Arbitration Act, by a deeming fiction, the award is made an order of accord. Now, my lords, please see how Vedanta, my lords, is section 36. Just note, my lords, the citation. I will not take a lot of time on that.
199 page.
Justice Malhotra's judgment.
Yes, Vedanta. Yes, yes, it is.
Yeah,
Yes, it is.
Whether that page 199.
It's 2020, volume 10 SCC, page 1.
One.
And the relevant portions, paragraphs are 69 and 70 at 244. It notes the concept of legal fiction and then goes on to Bengal immunity.
What else?
Then, Lords, the last portion is Amazon. Lords, your Lordships may just note, Amazon is
Paragraph it will be.
Amazon is para 75.
Okay.
2022, volume 1 SCC, 209. Paragraph 75 is what I want to show.
Yes. Does it anything more? Anything more?
Your Lordships may now permit me to show those two judgments. One is of the UK Supreme Court. What is the extent of this doctrine? Your Lordships may have Convenience Compilation 3. I'll just give the page numbers.
Give the page number. That's
The UK Supreme Court note starts at page 145. I am relying on para number 62 and 63 at page 167.
very good.
That is, Lords, inside UK Supreme Court, 5 judges. This follows a Sula America judgment. I'll just read that one sentence. It's the legal fiction purpose. Its purpose is to give legal effect to that intention, not to insulate the arbitration agreement from the substantive contract for all purposes.
Correct.
That's Sula America, accepted, Lords, by the UK Supreme Court. They are the creators, Lords, of this legal fiction concept.
What else?
Lords, there's one last submission that I want to make, but I don't want to waste your Lordship's time.
legal fiction exists. So we don't need any
That's
authority on that
Uh,
point.
They are, Lords, insofar as overruling SMS was concerned, Lords, I had, Lordships may see page 11 of compilation 3. I have relied on Keshav Mills, 7 honorable judges.
Page.
Page 11 of the compilation I have extracted. I don't want to read it. I have relied on Keshav Mills to show that overruling was not perhaps
Justified.
justified. And second judgment is the Supreme Court Advocates on Record 2016 5 SCC page 1 Constitution bench, that just because a different view is possible, overruling is not. Then Shah Faisal, my Lords, again Constitution bench, 2020 volume 4 SCC page 1, paragraph 17, 18 and 19, my Lords, I have extracted.
Yeah.
And to show, my Lords, this perhaps was not the right thing. Including, my Lords, when a reference has to be made to a Constitution bench of the Parliament
That's
on both counts.
Yeah.
With this, Lords, I just want to point out that we made a mistake. I must candidly admit. We said before the Honorable High Court, as also Lords before this Honorable Court, that the work order that was given to us, Lords, which fall in the Article 63 of the Stamp Act Maharashtra. Article 63, Lords, is a works contract. It is not a work order as our contract was simple transportation of coal. It did not involve any transfer of property as such. So that was a mistake that we made, and because of that, the penalty was 8 lakhs. Those are my submissions. I'm very grateful.
Thank you. Yeah. Now, who's that? You want to say something?
Yes, ma'am. One of the
What is
issues,
your name?
Malvika Trivedi. My lord, we had also prepared a compilation and my lord, the submission, but my lord, we will cut them short.
Make them short because you are intervening and that
Yes. Yes, my lord. Now, my lord,
anything which is not said alone, you will confine yourself to that. I mean, don't
But-
adopt the people.
not at all. My lord, in fact, I have cut my submissions into less than half because
Well-
taking note, yes. My lord, In fact, our entire concentration is on section 9. My lord, because the reason is that even though section 9 was not under consideration before the Honorable Court in NN Global, my lord, yet in para 37, which has been pointed out, specifically it has been stated that interim orders can be passed. My lord, that is the difficulty. Today, whatever this Honorable Court holds as far as 11.6a is concerned, in respect to the Stamp Act, should also then, my lord, apply to section 8, should also then apply to section 9. My lord, this is the anomalous situation that will be created today because of NN Global holding, my lord, two errors. One, my lord has already noted, arbitration agreement has to be stamped. My lord, repeatedly it has come in NN Global that arbitration agreement is not required to be stamped. My lord has seen Article 51C, it has to be stamped. Number two, my lord, severability. The basis, my lord, is severability. So, my lord, on both counts, when NN Global decides on this issue of 11.6a, it also, my lord, touches upon section 9, which was not an issue, which was not argued, where the arguments were not placed before the Honorable Court. And, my lord, it actually now puts a stamp of approval on the full bench decision of the Honorable Bombay High Court, Gotham Landscapes. Now, my lord, that has become a very big issue because Gotham Landscapes came first in line before Garware. My lord, Gotham Landscapes came on 4th April 2019. It decided on the issue of section 11 as well as section 9. Two questions were framed. Now, my lord, Garware came on 10th April 2019. It overruled Gotham Landscapes on the issue of section 11, but because it was not considering section 9, it left section 9 untouched. My lord, thereafter, Vidya Rolia came, which cited with approval, my lord, Garware, and my lord, then NN Global, which came, my lord, 11th January 2021, which, my lord, again, without this issue being before it, again put its stamp of approval on the law as has been held by Gotham Landscapes. So, my lord, today the situation is that whatever this Honorable Court will hold for 11.6a, if it applies to section 9, my lord,
And also,
then
eight.
Absolutely, my lord, because it considers both existence as well as validity, as the section itself says. And my lord, in 9, there is nothing in 9 which is similar to 11. It does not say confined to the existence.
What do you say about section 33, the opening words, receive evidence?
Absolutely.
What do you say about
So, my lord, therefore,
See, section 8 is by the court as defined in the section, before a court, civil court as such,
absolutely, my lord.
where it is competent to receive evidence.
Absolutely.
So is section 9. So that is also before the district court. I mean,
Lord, I will show by way of 9 and 17 both
Yes.
that now that they are held to be akin, my lord, there cannot be a different standard applied for the purposes of 9 and a different purpose then, my lord, as a consequence of deciding 17.
When the court, Supreme Court or High Court is considering 11, they are asking you whether it is an authority authorized to receive evidence and is the evidence being received when the arbitration agreement, be it original or certified, is being taken on board, as it were.
My lord, in my respectful submission, the admission of evidence, my lord, will only happen with the tendering of the affidavits, as far as an arbitration is concerned. My lord, as far as 9 is concerned, when the document, the main contract has to be looked at, it has to be acted upon because a prima facie case has to be seen. Whether it is a bank guarantee case, my lord, whether it is a termination case, whether it is a receiver taking possession of goods and returning it to the claimant, maybe for the time being, all these issues, my lord, require acting upon the main contract.
What kind of must be looked into even in section 11.
Absolutely, because, my lord, I am saying that it cannot have different standards, my lord, for the three sections, 8, 9, and 11. the Stamp Act application as it has to be done for 8 and 9 has to be done for 11. Because otherwise it will create, my lord, a problem here. Because what has been repeatedly canvassed that this is for the smooth ongoing proceedings in an arbitration. My lord, in my respectful submission, the arbitration will still stop even after reference. Because of the evidence stage, my lord, the arbitration will still be stalled. So therefore, because of the stringent provisions of the Stamp Act, and because, my lord, it's a fiscal statute, it has to be seen at this stage because many sections come into play. And that is the reason why, my lord, touching upon 9, my lord, even the observations as far as 8 are concerned, I just want to demonstrate, my lord, only by showing these 4 judgments, I will demonstrate, my lord, why it cannot be done after, my lord, because of NN Global, my lord, only then discussing 11.6a and making, my lord, these observations on 9. My lord, it really creates a problem that for one section you will look at the agreement, for the other section you will not look at the agreement. My lord, that is the difficulty today. And if, my lord, it is applied to 9 saying you will not look at the main contract agreement, then, my lord, how are these interim reliefs going to be granted? How is this then going to be decided as a prima facie case? That is, my lord, the issue. And I will also show, my lord, the main contradiction in para 26 and para 37 in global. It is self-contradictory, my lord, in terms of section 9.
Got the other key. We've got the other key, which will be my,
Lord is taking 504.
yeah, the other one, we will be calling that a case law. But we come by about 250, let us see where it goes, because
Yes.
they have not given the joint kind of petition which it asked them to give. We don't know where it's going to go.
My
We
lord,
get by 215 at least.
my lord, I'm appearing for the respondent number 1. A small compilation is there, my lord. I'll be filing.
You're
Unsettled. For the respondent number 1, I'll just take.
You're basically going by the arguments of the amicus.
Yes, my lord. But a few judgments and my lord, unsettled model.
That's right, that's right.
Just
Model has been, I think, given.
yes, my lord, and the judgment of Justice Bandari, my lord, and other judgments on harmonious construction and debates, my lord. Few debates, relevant debates and evolution. My lord, from 1996, debates in the parliament.
Otherwise, you do not wish to have any oral submission. You're
Not much, my lord.
That's
Just,
enough. I mean, if
just
you're-
10, 15 minutes. That's all.
Evolution.
Evolution, my lord, and debates. Not
Yeah.
I am just placing this, my lord, before your lordship.
Okay.
Yes.
Yes. We were eagerly waiting, that you would make available that you had promised that you would make it available.
Yes, this we have, after meeting, we have prepared a short
Yesterday it was
chart.
completely ready. Oh, this should have been secured yesterday, is it?
Yeah, we were querying, asking from the office.
Okay, no, sorry, but I was not here. I was in the family.
Yes, sir.
But anyway, I had the chance to speak to other doctors. They sat over the weekend. They had multiple meetings, a couple of meetings, and they have.
Let's see.
That's the flow chart which you have.
But before the flow chart, this is the summary of what we discussed. Now the flow chart is varying with this summary only in one part. I will just come to that. I'll give the chart which we had discussed, and it's the same thing, only two small variations. I'll come to that later.
Hmm. Yeah.
This is the one we broadly agreed. I think only one reservation they have is that once the primary board doesn't agree, they want that to be again referred to the review board, which we are not acceptable. This is not a situation under which, this is not an appeal or anything. That's the one.
So you now just tell us what.
The only thing is, what I was, when I spoke to doctors again at Bombay, and also here, this time allotted, they're saying primary board within 24 hours and review board within 48 hours, because what they're saying is every day in the ventilator is agony for the patient, and the primary board doesn't require 48 hours to come to a decision that it's terminally ill, etc. So one request is on the left-hand column, Lordship makes it 24 hours. And they say review board, in fact, they are saying review board, many people feel there's no need for a review board, but since they're having a review board, let it be there in original judgment. I would say 24 hours, 24 hours. That's one point. And secondly, Milord, this secondary board, sorry. Lordship has got secondary board in the middle, Milord.
Correct.
This one or this one?
No, this one. Because here, everything except there are 2 points of differences. One is this 48 hours, 48 hours. They're requesting it 24, 24 because time is of the essence. And secondary board, doctor nominated by CMO. Our suggestion is not what we had suggested, and in fact, the discussions took place, they initially agreed. Instead of having every time a person nominating, let there be a review board wherever available, where this review board is always there. And that they can take a quick decision because the primary board has taken it, they've got a report, they give reasons that he's got this 4th stage cancer or 4th stage this point. The time is very limited. So the review board, because again, if you nominate the review board, that doctor must be free, he must come, all those problems will arise. So
No, this, when you talk about
secondary board.
yes, you have said 2 subject experts not part of the primary board.
That's agree. That's fine.
Now these.
Although the only difficulty is doctor nominated by CMO. So the Lordship can
right.
think of some modification.
So nominated by, no, you have said doctor nominated by the CMO plus 2 subject experts. Are the subject experts also to be nominated by the CMO?
No.
This is what we want to know.
No.
Second thing is whether the 2 subject experts must be from a different hospital.
No, not necessary.
I mean,
We did discuss that threadbare, not necessary.
when you say not necessary, we are only putting to you that there may be cases where you may not get, the first board will have a subject expert. Then if you will need to have another 2 subject experts.
Yes, if they're not available, they'll go to the nearby hospital.
That's what you.
Wherever available. No, suppose it's like Safdarjung Hospital or say in Madras Government General Hospital, which has got a 10-story building with 200 doctors, then there's no problem. In fact, I was suggesting to them that because it's a trial basis, because like any product you have a marketing, trial marketing, whether to start it in major hospitals, but they didn't want to complicate it. So I'm also not getting into it. So, one is 24 hours, 24 hours. Now, your Lordship may suggest what instead of nominated by CM, if your Lordship has got some suggestion to make it
What does
workable.
48 hours mean? It starts sticking from when?
So, from the time the patient is admitted, and or suppose he's there for 8 days, 8 days he goes into a coma.
Once constituted.
If you tell us,
Once
this
constituted.
48 hours will start from when? Does it start, clock start ticking?
Constituted. Once constituted, they have to, once it is constituted.
my doctor colleague here says that 24 hours from the time they know that the end is inevitable.
It is 48 hours, isn't it?
No, we want to suggest 24 hours because uniformly they have made it 24. The government is suggesting 48. We are sitting at the primary board because they are the treating doctors. They don't require 48 hours to make up their mind. If he's
This is
treating him,
also difficult, no? Doctor will say that end is inevitable at this point of time.
yes,
I mean, 48 hours is, I think, very reasonable. That is not,
or Lordship can say not more than 48 hours,
they can do it at the earliest.
but not more than
But
48
not
hours.
more than 48 hours.
Yes, that's okay.
And that too, this cannot be, supposing you do something beyond that, then will a contempt lie? We have to be careful.
No.
Somebody will come and say that 48 hours is
We'll see you in charity, but it has taken
don't
hours
say
to.
that we will see it. We have to, Tatar, you have to be careful. The direction of the Supreme Court, it will be binding.
Yes, Lordship may say not more than 48 hours. Within 48 hours. Within 48 hours.
So what is the new?
Within 48 hours is not.
Whether it's
Within 40.
primary board.
Body board.
No. 48 hours to give the opinion. The primary board is the
No,
treating physician.
how does one file a petition, or how would that happen?
No, there are two cases. There is
They
the
have to
advance.
obtain the opinion of the primary board.
Yes.
No,
They are
initially,
reviewing on that.
the attending doctor to advise that
No, there are two cases. Cases where advance directive exists, cases where advance directive doesn't exist. That is para 198 of the judgment and para 199. So 199
even
if
if-
advance directive doesn't exist.
even if
No.
advance directive exists,
Let's go to that category first.
huh,
So just for easiest.
then also it's difficult. Somebody must say that it's a point of no return.
Yes, that's a treating physician.
That has to be treating
The
physician.
treating physician.
Then he will refer it to the primary board.
But he is not, his opinion doesn't count. He has to bring in two
No,
more experts who
He has to
concur with him.
refer it to the primary board.
He is part of the primary board.
Okay, so he
Part of the primary board. So it's treating physician plus two more. So within 48 hours, we said 24 hours, Lordship is saying within 48 hours can be even, because suppose a.
This is applicable only in the case where there is an advance directive.
No, that is, I'm just saying two compartments. One is advance directive where the person's wishes should be respected.
Correct,
And what the Supreme Court says is that should be respected.
correct,
And the primary board decision is only subject to a review board.
correct.
Now, suppose there is no advance directive.
Then we are not here to.
No, that's para 199. That's a very important part of the judgment.
Let's therefore see which are these provisions, how do you superimpose them?
Yes, here.
Which one?
I'm just saying. No,
Here
no.
we don't have it.
No, I just go step by step.
That's right.
If the advance directive is there in the format suggested by the Supreme Court, which
This is a
is
joint
made,
submission.
signed by two witnesses, etc. Lord, can I do one thing, Lord? Better is this is the agreed, like a minute which we discussed and agreed upon.
This one.
No, this narrative.
we'll have to place it along with the directives already exist.
Lord, what happens
We'll
is,
see
Lord,
which
this
part
directive
is
and this chart matches except this 48 hours and secondary board. Everything matches. This is a very simple format. Instead of reading 8 pages, this is,
And also doing away with the judicial magistrate or whatever.
that's completely done away. The judicial, then we might as well close the case. It's not possible. Then there's no point in having advance. Only intimation to the judges. The entire para 199 of the judgment. at
No,
page-
but Natarajan, this judgment was only dealing with cases where there is a advance directive.
Advance
Para
directive.
199.
I think Mr. Doctor
Yes.
does take into account a situation where there is no advance directive.
Yes.
And paragraph
99
199 deals with that.
No, it's only with that. Then
That's
you have to, then you require the consent of the kith and kin. Then the doctor can counsel them.
No advance.
Just read para 199 so that
Yes, yes.
there is a clarity.
At page
Mr. Natarajan,
133.
you are also.
Yes, in case there is no advance directive, that's what it says, second sentence.
The advance
Para 199.
Where there is no advance directive, the procedure and safeguards are to be same as applied in case for advance directive.
So it's 199.12.
Yes.
It is the same. Huh?
Yes. Broadly the same.
Is there any difference?
No, only the consent of family is required. The very idea around the rate, you don't need the consent of family. The patient wishes is respected.
That is with
Advance
advance.
directive, yes.
Without that, it's going on now also,
That's what.
with consent of the family.
No, now what happens is with this Supreme Court judgment comes, then there is no allegation, the doctors are protected. They consent. Now, without advance directive, they get the consent of the family. The family can choose, no, I want the person to continue indefinitely. If they're willing to pay for it, yes.
What will happen if a family consists of the wife and say two children? And what is the definition of family? Would you take in brothers?
Immediate family, basically. Immediate family.
What do you mean by immediate family?
Available.
We are telling you what you'll run into problems. We are telling you.
Not what.
Supposing you have, say, the wife says.
No, Lordship, imagine a practical situation where X is, suppose a senior lawyer finally goes to the hospital. Who will be the family, his son, wife, etc. Now we can't say his brother also is there.
Supposing we are asking you.
Yes.
Supposing say the 2:1. Supposing if a close family, say wife and two children, let's take it.
Yeah, well, I discussed that. Then what they say is, then the people will say that the person, the family which wants to continue will bear the cost of the treatment. They will bear the cost. Because when the doctor has said that there is no point continuing the treatment. They define what is family.
Okay.
In page 7, I just read it.
Anyway, we will not get into that.
The spouse or de facto spouse or partner with whom the patient has a relationship as a marriage or a friend.
Why should we incur a honestness and create more problems? we thought that it should be Nataraj's lookout to tell us, but
No, but AIMS has got it, Lord. Spouse, adults, sons, where available. Then if adult sons, children not available.
okay, now we have got it. So both advance directive and no advance, both
Yes.
it is applicable. Now let us see which are the provisions which are to be modified.
Yes. Now, if your lordship wants to
So
speak.
this is a clarification petition. We have to bear in mind. We can't take it
Correct.
unless there is complete consent.
Yes.
You
No,
know,
but I'll do one thing. This is the chart they gave me finally.
That's right.
This also matches. Please tell me this matches. Only where there is a point of difference is it 48 hours or 24 hours?
We intend to dictate the order right now.
Yes.
To what?
Yes.
So that it can be done any correction.
Yes.
modification can be done.
Yes. Now, but only thing your lordship has to say.
So what we intend to say, the format is we'll tell you what you've done. Just say what the clarification, and then the preliminary
Yes.
hearing.
But your lordship.
So today you have come to us, and we'll set out the procedure which has been laid down in this clause, so that anybody who reads the order, we will know.
But we have suggested in the narrative form. Lordship may follow this if your lordship so pleases. This chart, which is called, it's got into 7 pages.
No, what we have to do. See, there is already directions. One set of directions.
Exactly.
So to what extent those directions, which are those directions which will stand modified?
That is also done. 3 things are done. This is the modified directives. This is the chart for your lordship's easy reference. And this is the final chart which they gave me just now before lunch.
So let us see that, modified chart.
Yes.
Because
What they did.
if we give the original chart, original directions, and then we say that it is clarified that, then that will do the
It'll be
trick.
easier. It'll substitute
It will
that.
be both, so
Your
that
lordship is
somebody
right.
who reads it will know what is, this
I appreciate. Lordship is right.
is what the format we intend to do.
Yeah. This is the latest chart with black and reading.
Where is it? This one.
Yes. Lord, is it the page 1 ends with 198.3.5? The first page, does it end?
That's right.
That's the chart.
3.1. With a red dip.
Yes.
That is, and attested before a notary or.
Your lordship suggested, and your lordship said put or gazetted officer.
Page 7 and para 7. Page 7, para 7 of this note.
No, don't come to that. Don't see that right.
This need not read.
Not only now, black and red.
So, you have said in 198.3.2, that the witnesses and the notary shall record their satisfaction.
Yes.
Now, in the earlier clause, you have permitted and attested before a notary or gazetted officer.
All right. Lordship is right, because it'll be in synchronization with one.
Yes, because supposing it's before a gazetted officer, he should also certify
Right.
witnesses and the notary or gazetted officer, correct?
Yes.
Shall record their satisfaction that the document has been executed voluntarily and without any coercion or inducement and with full understanding of all the relevant information. Then what is to be done with this, what do you call this, advance directive? What we had in mind, we had a discussion. One more additional safeguard we wanted to incorporate, which is that once this is done, they should get back to him that he confirms in writing. It is just an additional safeguard. See that you have done this, and he writes back. So that will be kept along with the original declaration. This is to avoid any kind of fraud which you can, and it's somebody who is doing it in writing.
Leave it to your lordship, because suppose I go to the gazetted officer, I sign it before him. Now,
or he comes before you.
Whatever it is. It's very unlikely. He may want me to come before him or for a notary. Notary, I'll have to go to the court campus and get the notary to do it. Now, I sign it before him. Signed before the notary, public witnesses are there. Now, in my humble submission, it may not be necessary for them to ask me, are you really written? And I write back to him. I'm signing it before them.
We know that, but we are just saying in our country.
You can put it in lordship. Because what I spoke to some doctors again in Pune and Bombay. They said that
What
all over the world.
Some safeguards, whatever this one.
But that'll. Then where is?
No, because in a will, we don't say, did you sign the will? Yes, I signed the will. I signed it.
No. What is to be done with this? What is to be done with this?
Which one? No, that goes to the National Record Mission. That's coming later. The National Digital Health. Yeah.
Probably independent countersign.
But I'm told that later in the day, this document is handed to the family members. One copy to the Gazette officer, and one electronic record is kept with the national part of the digital health record. So even if I have an accident somewhere in Bangalore, it can be accessed anywhere.
So these notaries are governed by the Notaries Act.
Yes.
Is this a document which is actually contemplated under the Notaries Act? Because
Yes.
they got a stamp, etc.
No, there's a notary stamp. He puts
That's
a
right. So is this a document?
It's actually rubber stamp. He doesn't put any court fees. He just puts a rubber stamp.
That's right. That's right.
He's authorized. He's been authorized by the respective high court to be a notary public.
That's right.
Authorized to administer.
So do you want to? Be done this.
In page 2. The Lordship's answer is in page 2.
So we are deleting, we have to also now see that JFCM goes out,
Yes.
shall forward one copy to the district.
JFMC goes out.
That is also going to be deleted?
Yes,
Nataraj, you're agreeing with that?
Yes.
All right. Then 193.5 shall inform the immediate family members of the executor, it's not so. Executor shall inform and over a copy of the advance directive to the person or person named in paragraph 192.5.
This was your Lordship's suggestion.
Hand over a copy of advance directive. Within what time? Supposing he gives it after the, fix the time.
Let it be, Lord. You can't, because expeditiously.
Put it within a month. So that, it will become certain.
Because I spoke to some doctors who are dealing with some similar cases. They said throughout I'm not talking Western world, they said they take it like a will. It's just a declaration that it happened, that's all. There's no great formality. I must put it to some US medical record and all that. The document is just available, that's all.
98.2.5 is who? 198.2.5 is who?
It's in the 198.2.5
Ah,
is immediate family, one second.
should specify the guardian or the close.
Specify the guardian or close relative who in the event in becoming incapable.
So it'll go to him.
And Lordship said put guardians. Lordship said put in bracket S. Guardians,
That's right.
guardians or close relatives.
That you have not put in this note.
No, only what is to be modified. Lordship wanted only the thing which are modified.
That's right, but it should be there, no?
The 190 is not being changed at all.
198.2.5 we have suggested.
Yes.
In place of guardian or
Okay.
relative, it should be S.
Yes.
Because if case that man dies,
Yes.
or he becomes incapable.
Then 198.2.5 should become plural.
That's what we are saying.
Your Lordship is right.
198.2.5. We are writing it here, eh?
Yes.
Sure. 0.2.5 will become parent. I mean, guardian will become
Guardians or close relatives.
or it will become relatives. That's right. So that is okay. Then 198.3.6.
Yeah. Your Lordship asked who? You also choose because of privacy issues. Lordship said that leave it with discretion.
No, this 198.3.6 original will remain. You want this red portion to be added.
Yeah, the original portion will be there.
Will be there.
Yes.
Ah.
So only the red part will be added and aforesaid will come. Oh, aforesaid also this. Aforesaid also is there.
Do you want to put any time limit within which they should do it? Not necessary. Okay. So a copy shall be handed over to the ground. No, you are adding what actually? This red portion is to be added, that's all. No? We're going complicated. But you have said something shall be handed over to the ground. After that,
That's the same paragraph.
Repetition of.
there is a repetition. No? What we thought was,
Yes.
this red portion can come at the bottom of the original clause.
Correct. All right.
Then we don't have to add that. You follow. So we are just cutting that portion.
And
The
shifting
right
it to
hand-
the bottom.
Huh?
And shifting it to the end.
That will come to the bottom of on the left hand side.
Yeah, I agree. No.
That then JFCM that is deleted. Natraj, no
Yes.
problem.
Yes.
In the event, then comes 198.4.1 becomes terminally ill. In the event or is in the end stage of a chronic disease
But this comes from the ministry, my lord.
and is undergoing prolonged medical treatment with no hope of recovery and does not have any decision making capacity. .1. Have a day's reflection and dictate it tomorrow. I mean that to dictate it tomorrow.
Yes, please. And I would request if your lordship still feels something else, we have to mull over. So it's a bill. Because it will be now, what your lordship pass will be now permanent.
You see,
Till they pass a legislation.
One should go through it.
But can your lordship go through it just now quickly?
That's right. So that whatever.
As if your lordship has got any particular doubt, then
That's right.
No. Because I'm not having doubt, I'm technically.
So now this, what do you say, 198.4.1, this is a radical change.
sorry.
The radical change is or in the end stage,
No, that is the request of the ministry.
whether it's the ministry or whether it's you.
No, that's also just
Completely
another choice. The judgment.
We are tinkering with the judgment.
No, the Chandrachud's concurring judgment also says that. That's also Article 141.
No, that's not. So this is completely changing the.
Or delete it, Lord. Delete it. Anyway, it's terminally ill.
In the event, yeah, that's what we thought. And is a prolonged under.
I have no problem about it. It is a ministry suggestion, what you want to, because terminally ill is terminally ill. But terminally ill is wide enough to include this. Technically speaking, it's a genus.
It's a gene.
Terminal ill can be all your species of that.
Absolutely. Terminal ill person would also be in the end stage of chronic disease. Why do you want to, Nataraj? Why are you insisting on that?
No, they thought there should be some kind of check on the authenticity
No, why
and
we are saying
situation
the
also.
original.
No, they meant doctors also.
It's a clarification.
Yeah.
And we should not be, doing it on what those judges taught and, conducted.
Very well.
Because if the first part takes care of it, because it says in the event of the becoming terminally ill
I think we'll read it.
and is undergoing prolonged medical.
No, no, Rajshri, straight away cut it out.
Yeah. We are not English.
There's a saying, Mr. Datta,
Yes.
when thinking men think there's nothing to think, it becomes time to think.
Very, 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 very profound also.
And then you have added another red there and does not have decision-making capacity.
This is very necessary, my lord. This is very necessary because I may have an advanced directive. If I have a decision-making capacity, I can change my mind also. So let that be there.
For a change, you are turning pro-life.
For a change. No, Lord, I am not pro-death, my lord.
And cure of the ailment, one cure of the ailment. Then you have brought in treating the when made aware of the ascertained genuineness and authenticity of reference to the existing digital records of the or from the custodian of the document mentioned in. That's okay. That addition is, I think, welcome. So we'll get this information from either this or that. That's okay. That does not have decision-making capacity. What you said is, I have no problem with it.
But they're very serious about it. They want it.
So he may say, I don't want it. He said, don't do it, something like that. Or he is saying, do it fast. You don't know. All right. So that is, I think, something to what you may think about it. We can. Then comes 198.4.2 instructions. The document must be given due weight by the doctors.
Again, that has to go, my lord. 198.4.2. Again, that chronic illness can be cut off.
Or in the end stages.
That's been cut off.
Not at all necessary.
Not
Then comes
198.4.
0.3.
That's very minor.
If the physician treating will is satisfied, the instruction given in the document need to be acted upon. We shall inform the person's name. Yes.
That's the automatic, nothing good.
That's nothing much in it.
No, your lordship has to really decide on 198.4. There we require your lordship's inputs. The bench has to decide on that.
So the person so-and-so has replied, the steps for change. Then 198.4.4.
Yes, that's what I'm saying. There your lordship has to take it.
Hospital where the executor has been admitted to medical treatment shall then constitute a primary medical board. I just want to highlight one, supposing somebody was executed an advance directive, gets admitted in a hospital with just the rudimentary medical facilities. What will happen then?
Nothing. There will be no primary board.
There will be no primary board. Then what will happen then?
Nothing. Then he continue treatment or he will die, whatever happens. Nothing can be done. Lordship is right. Suppose a person gets an accident in the highway somewhere, he is taken to the nearest health center. What to do?
What to do? Nothing can be done. Okay. Admitted for medical treatment shall constitute a primary medical board consisting of the treating physician and at least two experts with. Now, this is a major thing. You're going to cut down, take out the 20 years experience safeguard, substitute it with subject expert.
Or at least 5. Because the answer was the person gets subject expert when he's 33, 34. He has to study, keep on studying till 24, 25, 26. After MBBS, then they do residency, then they do MD, then MS and so on and so forth.
And you're making it 5 years.
5 years experience.
What is the view of the government?
They agreed to this. These are all agreed suggestions, Manoj.
That's right. We wanted to confirm to that. Nataraj,
Please.
Now, here we want to know how will this 198.4.4
yes.
it involves actually at head of the treating department and at least 3 experts from the fields of general medicine, cardiology, neurology. All of that goes.
No, we said about the 2 subject experts, that is with 5 years, that is sufficient to this.
Because Lordship said last time, subject experts will be better than instead of putting multiple departments.
What I thought of doing was that to add to that. You see,
No, I would suggest, let's just put
because
subject experts.
why the earlier bench thought it fit to call out these disciplines separately expressly.
But suppose a person is, let's say, having terminal cancer. So I think the expert will be oncologist. He's not going to call, say, somebody from hepatology or something like that. We just put subject experts. So Lordship also suggested, so putting on, suppose hospital doesn't have one doctor for that particular branch. And now they say, all these, is it one from each? Is it 2 out of 3? So all those problems come.
So the subject expert will be determined by whom?
By the primary board.
No. Subject expert-
Hospital. Yes.
Who in the hospital? Hospital means what?
The
Somebody
director
must
of
take that call.
The administrator, the director, the medical leader. So suppose it's a large hospital, say controlled by a large family. Suppose a family is running a hospital with 50, 60 beds. Father is there, wife is a doctor, children are. They will then, patient is treated by some doctor. That lead of the hospital will take a break.
This is the only area where I have.
For a hospital is to form a primary board because treating physician plus 2 more doctors, that's all.
Actually, subject expert relates to the patient,
Yes,
the ailment that is suffering.
Ailment.
So it is nothing to do actually with the decision of the, director. etc.
Because the director may not be in that field also.
So it will actually relate to the ailment of the patient.
Absolutely.
And my lord, this is Joseph, suppose it's a medium-sized hospital, they don't have 2 subjects. They'll have to get the neighboring or nearby hospital just to come and confirm.
May take up to witness's opinion. This is the preliminary opinion. Who in turn shall visit both the just to provide for that. Supposing somebody wants to knock out this man's will, and the time was really not ripe in terms of the advance directive and the ground
My
reality.
lord, only one thing is the man is.
What would happen is that you bring anesthesiast. He's a subject expert.
We are dealing with a case, person is terminally ill. If not today, he's going to die after 1 week. So there's no question. And I asked one doctor, he said, look, elementary, suppose
I bring a pediatrician.
No, I won't take him to the hospital. I will let him die at home only. Why should I take him to the hospital?
Subject
If a person is terminally ill, he's dying, he's in a coma, he's suffered a major stroke. So one question asked was,
can we add subject expert having regard to the nature of the illness?
Yes.
so when you say subject expert, that's what it means.
Yeah, just, to
Perfectly, it should be subject expert means it's relatable to the ailment of this one.
ailment of that person.
I was like your lordship said, terminally ill includes chronic illness. My humble submission is subject experts will include that. It's a given.
Let us not, leave it to chance. Let's say that having regard to the illness. What do you say, doctor?
Yeah.
You have any suggestion there? Because
Sure.
if you say subject experts having regard to the illness,
We can write with the concerned specialty.
Subject experts of the concerned specialist.
Specialty is a generic expression. It will include any specialty which is relevant at that particular moment.
that's why we said relevant to the illness.
He's saying put concerned specialty.
The specialty concerned. Concerned means concerned with the illness. This is how they have worded in other jurisdiction, specialty concerned.
Subject experts of the concerned specialty.
Specialty.
That at least that should be there. Okay.
It will make it somewhat specific.
Otherwise, they'll call some other specializing of at least 2 subjects expert of the concerned
No,
specialty.
lordship added at the end of 5 years. Of at least 5 years experience in the concerned specialty.
Okay.
That may be better.
Now, what do you say about this 5 years?
No, that 5 years I don't agree.
Huh?
5 years, no limit of experience should be any.
then it will be very difficult. It will not be practicable.
But 5 years is.
At least
We
5
don't
years.
learn neurologists.
5 years.
Neurology, he passed MBBS, then he did MD in general medicine, then he does MD in neurology.
If he doesn't do MD,
More than 10 years he has been in this profession already. A super specialist has put in 10 years of his life in studying that specialty.
Five years remain doctor. So that expert of at least. Now, when you say two subject experts of at least
5 years experience in
of
specialty.
experts with at least, it should be.
No, yeah,
Of
experts of at least 5 years experience,
With
with
at
at least, not put with, at least 5 years
expert
experience,
with at least
5 years experience in the concerned specialty.
in the concerned specialty. So it means that we should be clear in our mind because that is after MBBS, he does say, for example, MD medicine. Correct. The super specialty is DM medicine. Okay.
Another 3 years minimum.
That will be another 3 years. So when you're talking about the subject expert, are we talking about somebody who is that is DM or MD?
So just put 5 years, bro. Just put 5 years in it.
So
We want to at least know what we are doing.
No, why I'm saying concerned
So we
specialty.
are cutting down 20 years.
No, the
That's
point-
why we are asking you, we should be clear in our mind.
No, I'll put it this way.
You take another case, you take cardiology. The same way. You've got DM cardiology.
Yes.
I think you have got DM cardiology.
Yes.
So what is,
I'll put it
is
this way.
the
Suppose the
subject?
person has worked in the cardiology department, he has finished his MD general medicine, he has been put in the cardiology department. Then he doesn't get admission for 1 or 2 years. Then he joins after 2 years.
He would have done MD cardiology.
Yes,
You see, you can specialize in cardiology right after MBBS.
yes.
Correct?
Yes.
You don't have to do MD, medicine.
No, we cannot do that. After MBBS, we have to do MD in general medicine. Then we can enter the specialty cardiology or neurology or oncology, whatever it is.
Do you have to do MD medicine? I mean, to become a MD cardiologist?
It's a 5 years post-graduation. After post-graduation.
Only after post-graduation, we can enter the super specialty.
After MD medicine, then only you can go further for MCH cardiology.
Yes.
What doctor is saying is 5 years experience after post-graduation,
That is what I'm submitting.
after completion of
The
post-graduation.
super specialist has already been for about 10 years in the field. That is 8 years after, 6 years after passing MBBS.
When I spoke to doctors, they are saying, please, they are saying that, look, a man is terminally ill. It doesn't require a man of 20 years to know that he's terminally ill. We are dealing with cases.
Even the Sir can say that.
No, I can't say. No, but I'm saying it
What
doesn't
look
require
at
5
it,
years
say
experience.
normally you
No,
can.
what I'm saying is, since your lordship says in the earlier bench said 20, we can't make it 0. So that's the only way of working. What's the workable experience? Just put 5 years experience. When you say 5 years experience, when you say experience in the concerned specialty, he can do it only after he finishes his course.
After
Experience in the concerned specialty.
It should be after post-graduation.
5 years after.
No, but I'm submitting, one second.
Concerned specialty.
He can't do the concerned specialty unless he's finished his post-graduation. Let's look at it that way. When I say 5 years experience in cardiology, only after DM cardiology is taken 5 years.
What about MD medicine? Can a member?
According to us, that also should be taken into account. We can say 5 years after completing MBBS, it should be enough.
Or you can say of.
Because
Or we
I
can
mentioned
say
there could be many
with
parts of
at
India you may
least
not
5
get
years
doctors.
Of at least 5 years experience
After medical.
of the concerned specialty.
No, you can also say after
Of
5 years
the-
experience after completing medical education.
No, we have to say of the concerned.
Concerned specialty.
That has to be there.
No, I'm only submitting, when I say concerned specialty, it ipso facto means he has completed that MD course and has worked for 5 years. That is my humble, I'm putting it that way. Because he will not be a concerned specialist till he has passed the exam.
With at least 2 years expert, with at least 2 years experience of the concerned specialty is sufficient then.
More than this, more than this.
All right. Then what is the next thing? Who in turn shall visit the patient in the presence of his guardian, close relative, relative, yes, relative, here also
Yeah,
guardian,
guardians related, yes.
guardians, relatives.
Right, suppose
Here we may not.
in a lighter vein, the General Clause Act will apply to a judgment. Singular includes plural verbs.
And form an opinion within 24 hours the case being referred to it,
Yes.
whether to certify it so and so.
Or should we make it 24 hours our request?
And proving that.
Actually, we have taken maximum of 48 hours. That may include anything below even 8. Suppose you take. That is to be seen later, Manoj.
That's right. No, we want to say this.
That is to be seen later. That is to be seen later. Please, I'll see it later.
Once it is constituted,
I give
visit
you
within 24 hours. 24 hours they have to visit and at least 48 hours. All right. Then what is the next one?
Lordship is keeping maximum 48 hours, bro?
We have said that
Maximum 48 hours. Okay.
That's okay?
Within 48 hours.
No, maximum.
So up to 48 hours. Up to 48 hours.
So what have you written actually? The primary board may take up to 48 hours to form its opinion if subject experts are not available. What is that?
No, first within 24 hours, if subject experts are available.
No. This is completely different. Please read it.
Yes, the primary board may take up to a maximum of 48 hours to form its opinion if subject experts are not available. That is available within 24 hours.
So then can you have a primary board without that?
No.
It's a superfluous expression.
Eh?
Superfluous expression.
That's
the second part.
Then why did you agree for this?
No. Sorry, they're not superfluous, please. It's a great application of mine. Suppose the hospital doesn't have doctors within 24 hours, then they have to get somebody from outside. Then those will be, if you can, subject are not available within the same hospital. If subject is not available within the same hospital. 48 hours, Lordship, I would say subject also matters fee.
No, you have given 48 hours, that's sufficient. Again, saying that, if they
No, 48 hours, if the experts are not available in the same hospital.
This is completely unacceptable.
No, kindly see.
No. What are you saying? You're saying primary board may take up to maximum 48 hours to form its opinion if subject experts are not available.
No, we are saying primary board will take within 24 hours. No.
What does it mean?
Until Lordship. Please see it again. Primary board will take up to 24 hours.
Correct.
Suppose that hospital doesn't have 2 extra subject experts in the concerned specialty. They must come from some outside hospital.
Correct.
That may take extra time.
Correct.
So that also must be done within another 24 hours. Because the primary board, suppose it's a large hospital like government hospital or a large private hospital. They will have hospitals. Suppose that private hospital has only 10 doctors, they have only 1 oncologist. They require 2 subject specialties. So they'll have to get somebody.
What you're saying in other words is,
yes,
this 24 hours is in a case where subject experts are available in
the campus itself, like government hospital,
in the campus.
Hospital. Yes.
So the second red line is that when they are not available
within the same hospital.
Take up to 48 hours to form its opinion. It's up. So what you're saying is that 24 hours is over. Then they get only 24 hours to organize another team of subject experts from some other hospital.
Yes.
They'll be obliged to come and give it within the next 24 hours.
Yes.
I mean, that is, carrying it.
So, Dada,
That is carrying it through.
after such a long deliberations going on, I just put a stress on myself to know that is the reason the legislature is not coming to the place for the reason.
No.
They said that it is such a job for us, and whatever we do, day or tomorrow, something is wrong.
Or what Lordship may say.
So what we suggest, make it less complicated.
That's right.
Need something for
minimal as it is.
need something,
you can delete
need
it.
something for the persons who have taken the call.
No. My point is.
As simplify you do, as simplify it work.
Lordship is right.
If you suggest,
This is very complicated.
only
What I'm saying is, suppose the subject experts are not available in the same
So
hospital.
we don't want to fix a time limit of 48 hours, which is just 24 hours more. You look at the situation. Just
Then
because
Lordship may put like this. I'm just suggesting.
at the earliest.
No. May.
Complicate and expand.
Can I suggest like this?
Don't make it so,
Can I just suggest
by the hour and all that.
Mr. Datta, only one minute listen.
Yeah.
Page 7 we are referring to 199.1.
198.4.4. Page 3.
Sure.
This one.
This one, 199.1.
This is the second red line.
The second red line. I read with your permission. Primary medical board may certify the course of action to be taken. Now we are reading. Within 48 hours of the case being referred to it and stop. Leave the rest.
That's right. Done. Agreed.
Now simplify.
Simple.
And leave something to be done by the person to who has to take a charge. You can't put everywhere if and but. That fellow will just go around in the corners and find out what is my role. That's why with Nataraj I asked the people, please leave it. This court is doing this business, this court may continue. We don't want to step in.
We are completely tinkering with it like a review, because this is not contemplated by this court.
There is no occasion or requirement to complicate all these issues now, as and when this.
We're not
We shouldn't be doing it.
We all try to simplify, but still complication goes on.
This is the patient person.
As more as you read, more you find something.
Brother, even this within 24 hours, this ultimatum for forming their opinion, I don't think that. So they may need consultation. They may take because ultimately everything hinges on that opinion to begin with.
48 hours, 96 hours.
No, we are. I don't think
Within 40
as long as within sequence of time.
we should say at the earliest. Because there is no such thing in the main.
No, this 24 hours are agreed between all of us, Lord.
Preferably within 48 hours, that's sufficient. We can, rest of things,
That is
Preferably within 48 hours.
Preferably within is okay, because that will send a signal.
That's right.
So this.
Where it's a completely case, no chance, and they can take it within 1 hour.
No. They're saying that the first red, that is within 24 hours, we'll change it as.
Preferably within 48. Just add preferably.
Preferably within 48 hours.
Just add preferably there, Lord.
That is okay.
That's right.
Who in turn shall, this is so that other thing we are cutting out. The second thing red we are going, that goes. Within. Preferably, yes. Preferably. Within 48 hours.
No, they agree.
That is very fair. Not at all fair. 48 hours. 48 hours. Of the case being referred to it, whether this also. That's okay. The other thing goes. Then this next is in the event of the when the medical board, primary medical board certifies that the instruction contained so and so ought to be carried out, shall both to it constitute a secondary medical. So that is to be constituted by whom again?
Please see next page.
Hospital shall.
But I'm told in the panel of doctors under the Transplantation of Organs Act, where a person comes as brain dead or where the organs can be harvested. So as it is incompletely, they will take a call. So those panel doctors, and this is agreed between the ministry and the doctor, the Institute of Indian Society of Doctors. But who wants to see the copies of the act? We got the act.
They shall visit the hospital evaluation and if they concur with the initial decision also, so they may endorse the certificate to carry out. So physical inspection is necessary now. Shall provide his opinion within 48 hours. That is also again we are going to make it within 48 hours.
Preferably within
48 hours.
Preferably within, yes.
We can't put the knife to their neck. Preferably within 48 hours. Okay. So then the next sentence is this time may be extended to a maximum of 48 hours. That will go.
That will go. That will go.
That has to go.
Yes.
Correct?
Yes.
So the secondary board will be constituted by the hospital itself.
No.
Yeah.
There is no.
That's what I've agreed.
Yes. That's what I wanted to point out. What has been agreed or what is of this one, it shall be by the district medical officer. That's what we pointed out. One
That
doctor,
is what this court has also
yes,
said.
one doctor, and 2 subject experts who are not part of the primary board. That's all is the requirement.
Only one, what they said was in a large city like Bombay, I am staying, say, in Andheri. Where is the district medical or I don't even know. I've lived in Bombay for most of my life. I don't even know where Chennai. I don't even know where my district medical officer is.
You had lived in a smaller cities, you would.
The doctor.
It's in Calcutta. Do you know where? We don't know where the DMO is.
When we had to do our testing for.
It's the doctor and chief medical officer from DGHS.
We have to undergo a physical.
So, Naraj, who is to constitute this secondary medical board?
That's the only one doctor will be nominated by the DMO, district medical officer.
No. When the primary report comes
Yes,
and it's favorable,
yes,
then the secondary medical board,
yes.
that will be constituted by whom? Somebody has to take the initiative.
The local hospital that can constitute it, one.
You have no difficulty.
No, there's no difficulty.
Then which part of it that is your against?
One doctor shall be nominated by the DMO for the secondary board.
One registered from the, that's what they have said.
Not as they suggested here.
So what should be done then?
It shall be one doctor shall be nominated by the chief medical officer.
Okay.
Yes,
So that will be,
yes.
so board, they can constitute a secondary.
They can constitute the board.
But, so here we will say comprising of one board, etc., 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 etc. So before and at least 2 subject experts, we will add the words nominated by the chief medical officer. The problem will be solved.
Yes.
I think the same thing is there.
No, not seen. They said something about this one. No.
Here, you know, here we will say nominated by this board. comprising-
One I've got to interrupt.
You understood what you're saying?
No, yes, I understood, but it's not going to work out. What I'm told because there is a permanent panel under the Transplantation of Medical Organs Act. It's already there existing in the statute.
That's right.
Now, what they're saying is the person is dying. Primary board has taken a call. Now, as it is 24 hours plus 48 hours is there. Now, if you're going to start constituting a board, that doctor should be, they're saying when the panel is already available, why don't we use that panel is the suggestion by the doctors.
We have understood, but this is some kind of an agreed order. Let us not tinker with it.
Then Lordship,
It is, we are only adding this and nominated by the chief medical officer.
Correct.
We'll only say that it should be time limit. There should be time.
the point is where, because
They have to nominate.
no,
They have to nominate within a particular time.
But if I-
That we can add.
the DMO has to nominate, the DMO has to telephone the doctor, is he agreeable, not agreeable, all that, where is the?
I mean, can we completely tinker with the judgment?
No,
I'm
I'm saying,
going.
no, I'm just saying, you say preferably by the DMO.
I don't agree with that.
Once again, I think he's what he's dealing us and what he's correct.
And nominated by the chief medical officer, that's what I'm saying.
One registered medical, Rajan, you have it? Page
Yes,
Yeah,
yes.
one registered medical practitioner from a permanent
nominated by.
panel of registered medical practitioners empaneled by chief medical officer.
Of the district so and so may also designate registered medical practitioners empaneled under section 3 so and so, so and so. All those things are not required.
No,
We are only kindly put it in a simple words. One doctor nominated by the chief medical officer
Yes.
and 2 others.
Lordship will just do one thing, if I'm right, just correct me if I'm wrong. Just go to the first 3 red lines, not page 4. One registered medical practitioner from a permanent panel of registered medical practitioners.
All those things we don't,
Full stop.
those things we don't have to say.
No,
What
full
is
stop.
saying, why are-
Lordship will just put full stop after the district and
And one registered medical practitioner nominated by the chief medical officer.
Yes,
Why complicate it?
yes, she wants to say something.
Etc., etc.
But she wants it because she discussed.
Let us not, let's close it. I mean, don't keep it, like this. Very complicated.
Yeah.
Just one thing, which is that we.
Just a moment.
Yes.
One registered medical practitioner nominated
He's saying that from a.
by the
No, Lordship may keep from a permanent panel. There is a panel existing.
chief medical officer
No, there is a permanent
And-
panel nominated by the CMO.
and at least then it will read like this, and at least 2 subject experts of at least 5 years experience.
Who are not part of the primary board.
That also must be added.
Yes.
Who were not
Can you Lordship just tell us the sentence?
part, we'll read it out,
Yes, sorry.
part of the primary board. So it will read like this.
comprising one registered medical practitioner.
In the event of a medical, etc., certified so and so, then immediately constitute a second medical board comprising of one registered medical practitioner nominated by the chief medical officer of which hospital? Of the
district.
Otherwise, it will be not clear. Of the district.
Of the district.
Of the district. Nominated by the board, and at least two subject experts.
Yes.
With at least the same word we use as we have used.
Of it, subject experts with at least 5 years experience
in the
concerned specialty.
Now, same thing will.
Now, only one thing, just to reconsider one small point.
Just a moment. Yeah. At least let me complete that. With at least 5 years experience. Experience of the concern specialty. Yes, what is it that you want?
Yes. Now,
then they shall jointly visit.
That's all. That's all. Okay.
May say that they are not part of the previous board.
That also I have said.
Yeah.
Who were not part of the primary board. Were not part of the primary.
I have to just say one thing.
Yes.
Not now.
Yeah.
I am told
Yes.
that every district under the Transplantation of Organs Act, the chief medical officer has already created a panel of doctors who are permanently available. So what we are saying is the person who is nominating can be from that permanent panel. So every time they need not go and ask anybody, that panel doctor is there. That's why they said, am I right? From a permanent panel of registered medical practitioners who are already empaneled by the CMO. So there is existing today in law, the CMO has empaneled 4 or 5 doctors in a district who are under this act. So let them be there. So instead of him searching for a new doctor.
No, that is not acceptable. We deliberated upon it.
All right.
It will lead to a lot of.
We have already
Leave it there. Let's leave it. Yes. Let's go on.
It should be relatable to the
Correct.
terminal
Yes, yes.
terminal
No,
Yes.
no, that's not the point. About the,
Here
about the
also-
CMO.
Here also same thing applies.
So the same person should be.
Yes.
No, the point is.
We have said this. Now that's over. That clause is over. It is not.
All right.
Let us go to
Don't get more
198.4.6. What is that?
He'll appoint the panel. That's all. Person of person, that's nothing much.
No. This
Consent of the
you're-
person
you're
or person
deleting-
nominated by-
You're deleting.
The collector is not involved.
So that is gone.
Yes.
That is gone. Then,
Yes.
then the consent of the person or persons nominated by the executor should be obtained regarding refusal or withdrawal of medical. Okay. Why? What is this actually?
That we agreed, not the collector, let's not involve the collector.
No. What is this actually? What is this? 198.4.6.
No. That requires the collector to form another board, third board.
198.4.6. We are asking.
Exactly. Please see the whole thing. The board constituted by the collector must beforehand ascertain the wishes of the executor. If he is in a position to communicate and is capable of understanding the consequence of withdrawal, in the event the executor is capable of taking. So last time we said that the collector, don't involve the collector, he has no time. If the collector is going to form a board and that board is going to again ascertain, as it is that man is in hospital.
Wishes of the executor.
Yes.
What is the original clause? Please read. It says the board constituted by the collector must beforehand ascertain the wishes of the executor.
Who's the executor? The man who signed the advance directive.
Right.
Yes.
Just see what it
Yes.
says.
Yes.
If he is in a position to communicate or is capable of understanding the consequence of withdrawal, that's why. How do you cut that out?
No, but
Why do you cut it out?
But how does the collector constitute the board?
No, that portion we can cut out.
Yes.
Now what you have done is you have cut out the lock, stock and barrel, you have thrown it out. Please see it. You see.
Please explain.
Lordships, actually, this is an, if I may respectfully say, this is an error in the earlier judgment. Because you cannot ascertain the wishes of the executor because he has already lost decision making.
We are telling you, if it is not possible, let it not be possible, let it remain as it is. How are you affected?
Then Lordship may say the review board, the secondary board, don't put collector.
Collector will go.
You put secondary board.
Even otherwise, it is not the collector who is to ascertain. Please see what is done. The board constituted by the collector must beforehand ascertain the wishes, not the collector.
No, I know that.
Then,
What happened was in the earlier judgment, after the primary board, the collector to form a secondary board. He said, don't do all that.
we will say the secondary board.
It can be secondary board.
Secondary board, that's all. We will instantly, we will simply say that the secondary board, so constituted by the collector, will go.
All right.
Must beforehand ascertain the wishes of the executor if he is in a position to communicate and is capable of understanding the consequences of withdrawal. In the event is incapable of so-and-so, impairing so-and-so, then the consent of the...
All that can continue.
Yeah. Guardian, there you have brought in person or persons. Correct?
Yes.
There we can bring in person or person.
Yes. And first,
Not a wholesale
the secondary board must, the secondary board must ascertain the wishes if he is in a position to communicate.
That's right. Rest everything will remain.
Yeah. All right.
Rest is not, it's harmless and I let it remain. Okay, then 198.4.7. Hospital where the patient is admitted shall convey the decision of the so-and-so and the consent of the person named in the before.
Only intimation.
Before giving effective decision.
No, judicial magistrate, you just inform him. So this is going to be a big,
because that will be just withdrawing it.
just inform him, that's all.
That's informing it. That's okay. No change.
No, but let's put before giving effect to decision.
That's right. Before, what is the purpose of doing that? Just to tell him that it's going to be done. But
I have not said they agreed, but I think before giving effect to another 24 hours primary board, 48 hours secondary board, go to magistrate, he must be informed. And I don't know how it's going to work out, but we leave it.
Yeah.
Don't put before giving effect to them.
Necessary.
Or leave it.
Okay, leave it. Then 198.5.1, my God. If permission is refused by, it would be open to the person named that or even treating person approach. That's, I think it is.
Yeah.
That's okay, I think.
Yeah.
But Raj?
Yes.
Then 198.5. All this no change. Then come 196.4, where the primary medical board takes a decision not to follow an advance guide.
This is not.
The person or the person named in the advance directive may request the hospital to refer to so that's also okay.
No, this is if the primary board doesn't agree, there's the end of it. There's no question of referring that to the secondary board. It's not sitting in appeal, secondary board. On the decision where they said that it cannot be done. Only the positive decision can be referred again for the purpose of confirmation.
No, earlier Supreme
No,
Court
what
said-
is the earlier provision at this?
Yes.
198.6.4.
Where the hospital medical board takes a decision not to follow the advance directive while treating the person, then it shall make an application to the medical board constituted by the collector for consideration.
That's the secondary board.
That's all.
That's the secondary board.
No, yes, now what it is said, where the primary medical board takes a decision not to follow the advance directive while treating the person or persons named in the directive may request the hospital to refer the case to the secondary medical board.
What's wrong with it?
Then again, it has to go to the secondary board. They're sitting in appeal.
Same
Same thing here. It doesn't make any
The
difference.
collector's board, secondary board.
That's right.
Fine.
It means that this is before you take up 226.
Yes.
You go to the second kind of appellate board, which may take a decision. That is always contemplated, I think.
Take it.
Contemplated, isn't it?
Very.
So one board refuses, the other board can do. No change. Then 199.1.
What we have to delete in the end stage?
Where is that?
That end stage, that first red line has to go.
That's right. In cases where the end stage, that will go. Undergoing treatment. Everything else is there, which is
No, we said we did not agree on.
Lordship has put preferably within 24 hours. In that last three lines, so within 24 hours, please add the word preferably.
Inform the.
Then Lordship may say the time may be extended if the external hours, don't put 48 hours.
Be appraised to a certain
Then the primary medical board has certified.
Well, may I just mention one thing, Lord?
Time may be extended up to 48 hours. That'll have to go.
Lord, can I just,
This is
can
much
I
more
just put one
serious.
point?
This is much more serious because, you know, he has not given an advance.
Exactly. So Lordship has to say from this 199, it'll have a subheading where no advanced medical directive exists. Above para 199.
That's already there in the judgment. It doesn't, part of it. What you are concerned is not that. So the consent is there, and if you consent in writing. The one problem we are pointing out here is that who will have to give consent in writing? The family members or
Family member. Patient is in a coma.
Yeah. Who out of the family member?
The family member.
You can't improve on that.
Yeah, we can't.
And this primary medical board in the manner indicated earlier.
Yes.
Same way.
Yeah.
So that will be substituted.
Lordship may say in the manner indicated in para.
Indicated earlier is sufficient.
Para earlier.
That's sufficient. Then let us read thereafter. The treating team shall discuss with the family relations if any. And shall treating them. Now here you have said that primary board constituted a medical board in the manner indicated earlier. Where is it mentioned that this medical board should go and do inspection and then record a finding that he is so and so?
Meaning?
Is it there?
I didn't follow that.
See, it speaks about which in turn shall constitute a primary medical board in the manner indicated earlier.
Yes.
Thereafter, what is to be done? The treating team
shall discuss with the family physician.
No. Instead of the hospital medical board, you have made it treating team.
Yes.
Shall discuss.
Yes.
With the family physician.
Yes. You should make it primary board.
Because it was earlier a hospital board, it will be primary board.
Or I put primary board.
That will be because otherwise we are completely changing it, no?
Primary board.
Yes. So that will be family board. Primary board. The primary board treating shall discuss with if any and the next step is and record the minutes of the discussion during the next step shall be apprised. The pros and cons of withdrawal so and if they give consent waiting, the certified report of action to be taken within this again. This is 24 hours is coming.
Preferably.
Preferably within 48 hours. You want this 48 hours for this also? Because this is a case where there is no advance directive. This is being done by the hospital.
After the kit or kin have given their consent.
May certify the course of action.
The Lordship said, suppose you want to consult some more records, is there?
That's right. This is their decision shall be recorded as a preliminary. In the event primary medical certified the option of withdrawing. Should we say that after doing, after inspecting and all that is not there? We found that what is the procedure to be adopted by the medical board, that how they should go about it.
I'm sorry.
As to what should be done by the medical board, primary medical board, it's conspicuous by its absence.
They put no pros and cons of withdrawal. Borrow the Supreme Court language.
That's right. We are saying, doesn't say that they should do an inspection of the study the
yes, because when they say pro and con, they are already inspecting.
Implied. In between pros and cons, you take somebody's life. Okay. In the event of primary medical board certificate and in the event the medical certifies your option of its own, the hospital shall consider the secondary medical practice. One registered medical practice. But that also same thing.
But again, it will be like what Lordship, one registered, same thing.
Medical practice, nominated by the CMO of the district. Correct?
Yes. Or your Lordship may say secondary medical board constitutes the manner indicated earlier.
No, let it be like, anyway, we are putting it.
Okay.
That will be better actually.
Yes.
Constituted in the manner indicated earlier.
Yes.
Why create unnecessary second medical board? In manner indicated about it. Here and before. Secondary medical board shall visit the hospital for observations and after studying may concur with the opinion of the primary medical board. That intimation shall be given to the hospital insurance and so on. So the medical shall provide his opinion. There also we'll have to say what is it that we have to say? Secondary medical board shall provide its opinion preferably within 48 hours.
And Lordship cut off that subject or maximum can be cut off.
All those things we are cutting.
Yes.
48 hours of the case being referred to it. Then the last one we hope. What about 199.4?
Same, I don't think any difficulties there. I don't think they have any objection.
In such case, the patient's next of kin may request the hospital to refer the case. It's the same thing actually. May request. What do you say, Natraj, about this last one? 199.4. That's all right?
That's right.
The same thing.
Everything is applicable to this.
So then goes to Article 26.
In case of the you had something here in case where the primary board is the opinion that treatment should be withheld or withdrawn. But the secondary board does not concur with the opinion.
I don't put this. This can become the digital.
The medical board.
Lordship may just say whether
yeah,
you
this
go to
is
High Court, that para 200.
It says that you go to High Court.
Go to High Court.
I say if it's in the national digital, why bother about the High Court again? So High Court has to keep a separate registry, keep a file, keep a server.
No. It speaks about the right to go to the High Court.
Yes.
No.
199.
Having said this, we think it's appropriate to cover a vital aspect to the effect life support
Here,
is gone.
it has
The
to-
same shall be intimated by the magistrate to the High Court. It shall be kept in a digital format by the registry of High Court, apart from keeping the hard copy. Which
Where are
is
you?
registered of the
What are you reading? Where are
There are 200.
Oh, you are reading paragraph. That there is no change.
Just before that.
I thought if Lordship.
199.
We are sorry, we are on 199.4.
Yes.
Yes.
That of course that we
No,
are
there is some change. 199.4.
Ah.
Earlier it was once the primary board refuses, then he had a right to go to court under 226. See the left side para.
Now we are saying go to secondary board before going
No,
to High Court.
that is not. So virtually will be tinkering with everything. Now again they want that to be referred to the secondary board.
Right, go to High Court straight. No?
Straight to High Court it should.
No, but then we have adopted the same.
That is for the, yes, because it was provided in the previous judgment.
No, in the advance.
As it is provided.
I have no problem. If you want to go to High Court straight away, go, my lord. I have no problem. They're just trying to save the High Court's time. We just wanted that the family also is assured that if the primary board has said so, the secondary board has said so, then you go to High Court. But also doesn't want secondary board, I have no problem.
So we are here only, we will simply add where the primary board.
Hmm.
The only change that we'll be making is that we'll be adding the word primary board. Because you follow
Now, Lordship will see 190.4.
199.4.
Yes, my lord. First, primary board says you shall not withdraw the support.
Withdrawn so and so. Or the collector nominated but may not concur with the opinion. That let it remain as it is.
Yes.
What happens?
Either the primary board does not agree.
Then what happens? The patient is kept.
Go to 226.
Yes.
If the secondary board does not agree with the primary board.
No, if you're not going to, if either two steps are there, if your lordship is going to accept the suggested change, there is a primary board says no, you will not withdraw life
Into the
support.
matter.
But the relative says there's no point.
Ah.
Right, but the doctor says I will not do it.
Correct.
Then you can go to 226 and the High Court can withdraw. What we are saying is, go to the secondary board. The secondary board, suppose says.
We've
yes,
understood what you have said, but
You drop it.
we don't want to do that. So this is only, we'll add the word primary
That's
board
right.
in one
The
line.
the entire red line can be cut off.
No, we are just adding the word primary. There may be cases where the primary board may not take a decision. So we are adding the word primary.
It's already there, my lord.
No, it's not there. See, where the board may not take a
The
decision.
primary medical board.
That is what you have added. No?
Yeah.
We are saying in the original clause, we are just adding the word primary board, medical board you can say. You didn't, on the left hand side,
No, so it will be only one addition in the left hand column. I got it.
only primary medical board will be added. So this is subject to what, you know?
The lordship has removed collector and all that.
That's right, that's right. Or the review medical board. We can make it review medical, isn't it? Secondary medical.
Secondary board.
Reporting to the.
If a collector nominated medical board, it will be the secondary medical board.
That will be the only change.
Yes, two changes there. Primary board and secondary.
That's right. So now what did you say? If you want to dictate it?
The lordship will also have to cut off this independent committee consisting of High Court mayor. Let it be there. Let it be there.
Rule or something.
Use High Court
You
call.
wanted the date stand. He was green, he's agreeing. He's also agreeing. Agree. So he doesn't want that 1 day's time. Brother says we'll go with it.
Yes, yes.
So we'll close it right.
So whatever, I'm here tomorrow also. I can wait here also.
That-
No problem. If your lordship wants to, I think there's nothing more left because everything is this. Unless just
That is
postpone you want.
One, there should be parameter to 198.4.7.
Sorry,
198.4.7.
4.7.
Yes, that parameter provision should be given to no advance directive also.
For the,
Yes. Reporting to the magistrate, that should be incorporated for where there is no advance medical
It's
directive.
already there.
I don't think. It's not there, I don't think.
hospital where the patient is admitted.
Please see page
Maybe the
8.
decision of the primary.
198.7 is there. No, please use page 8. The secondary board shall.
198.4.7,
Yes.
where it mandates that it shall be given
That's
to
there is 199.2. Please
One-
see page 8.
199 point.
2. Please see page 8.
Give 1 second.
In that event, intimation shall be given by the hospital to the JFMC. By the
Chairman of the collector, so and so medical board to JMFC and the family members of the board, by the chairman of the collector.
In that event, intimation shall be given by the hospital to the JFMC and the next of kin.
Not,
Correct, I'm taking. Take the. Seeking clarification of the judgment which is in fact been reported in which is the 2000?
2018, 5 SCC, page 1.
Just a minute, brother.
What happened?
You have started.
This is an application filed by so and so. So whoever is the applicant seeking clarifications of the judgment.
Can I request something, Lord?
The clarification.
Yes, can I just request something, Lord? So you can say the judgment was delivered. It was then found by the medical community that directives are not working out.
That's-
Therefore, they assess.
We'll say that.
All right.
We have to begin.
Okay.
We thought we should begin with some little bit of formalism.
Yes.
Application by so and so of the judgment reported in so and so. What is the judgment?
2020, 2018, 5 SCC, page 1, common cause versus Union of India.
That's right. A constitution bench came to be constituted on the basis of a reference made to it by a bench of 3 learned judges. Please correct me if you can. In the backdrop of certain earlier decisions of dispute. In particular, this court was engaged with the question as to whether the court should issue suitable directions, stroke norms, or set in place norms to provide for what is described as advance directives. This court also was concerned with the question as to whether, even in the absence of advance directives, when a person is faced with a medical condition with no hope of recovery, treatment should be life support, and he's continuing on life support systems, stroke medicines.
This part, just little.
Yeah, I can do. The should be the life support system should be withdrawn. The court went on to dwell on the right of a person to die with dignity. Thereafter, this court has proceeded to lay down the directives as follows. You will take it down from 198 points so and so till right up to 200. Correct? Just take it down as it is. The paragraph. The applicant is approached this court within a short period, as we are advised to think, of the issuance of the directions aforesaid. The reason for approaching this court all over again appears to be that in the actual working of the directions, insurmountable obstacles are being posed. For instance, it is pointed out that this court has provided in direction paragraph 198 point so and so that in the case of an advance directive which is devised by a person, it should not only be attested by two, it must not only be in the presence of two attesting witnesses, preferably who are preferably independent witnesses, but also it should be countersigned by the judicial first-class magistrate. It is pointed out that this clause has led to the very object of this court issuing directions being impaired, if not completely defeated. There are other aspects which have been highlighted in the application. Paragraph. The respondent, namely the Union of India, has filed a counter affidavit. We find from the contents of the counter affidavit that the stand of the Union of India was that it opposed the application. As we have noticed, this is an application seeking clarification. Ordinarily, be it an application lodged in this court, blessed as it is with powers under Article 142, you would have thought that the application should not receive further consideration. However, we notice that there has been a subsequent development. The development is in the form of orders evidencing an attempt being made by the respondent also to agree to certain changes. Several rounds of discussion, it would appear, has taken place between the officers of the respondent union, which not unnaturally includes the medical experts, correct? Correct. Medical experts. According to the applicant, the difficulties which they have encountered have been spoken of and approved of by a large number of doctors. And it becomes absolutely necessary for this court to revisit the directions so that this court puts in place a mechanism which effectively carries out the object of this court laying down the principles in the paragraphs which we have already adverted paragraph. Having heard Sri Arvind Datta, Learned Senior Counsel, what about your name? Dr. Sonia.
R.R. Kishore. Representing Indian Society.
Also, you can. Yeah, you just give your name. This Arvind Datta assisted by
Dr. Dhwani Mehta.
Yeah, that's right. But then what is her? She's been. We are talking. Okay. Take that names also.
But are you also
Medical
doctor?
doctor. She's a legal PhD.
Okay. What is the name?
Dr. Dhwani Mehta.
That's you. That is assisted by, you can see already.
We'll give the name.
And Sri Nataraj, K. Nataraj, Learned Additional Solicitor General, appearing on behalf of the Respondent Union. We are of the view that the directions contained in paragraph so and so, so and so to so and so, so and so requires to be modified, stroke, deleted as hereinafter indicated. Paragraph. So then you have to take paragraph 198.3.1 shall read as follows. Correct? We just tick and give it to you. Because all these things which are agreed.
But may I suggest that the Lordship can put in it will be a reported judgment. So if it can be in
We
a
are not
table,
very
it will
keen
be
about
there.
that. We are not very keen about it being reported.
No, it should be. The whole country should know.
All right, let it be.
So then it's a table that you can understand them.
Yeah, so we have already put down the directions earlier.
No, Lordship has put in a direction earlier.
But you want that to be
I'm
table.
just suggesting, Lordship may think about it.
Tabular.
We can put it as a table.
Table.
So we can, even if it is repeated, because it doesn't matter. But you just put this as it is. Yeah. As it is. And with the changes which have been brought out here.
But can I suggest that I'll give a soft copy to the court to be easy, so retyping everything.
That's right.
I'll give a soft copy.
Whatever
so that it'll be easier for them to, instead of typing all over again.
No, because we have also brought about some changes.
Correct. So in that soft copy, they can make all.
That's right. If that is so, let it be done that way.
Yes.
There's nothing more to be done.
That's all. I'll ask them to give a soft copy on a pen drive or something, or email it to them.
Provided it contains whatever is the changes that we have brought.
Yes, yes.
It will be Order. Whatever is indicated. Correct.
So only one last thing.
Anything more you want?
No, the only thing there, Mr. Shuri,
No order has to cause.
no, this is what I was mentioning about Arun Shuri. I was thinking over the weekend. So I said about this book preparation. He has personally signed the copies for each of them. I also get a copy to Mr. Mukherjee. Not a very good book to give as a gift, but
I want to give a reminder of that.
he has signed it personally for everyone.
You have to give direction to
Each of them.
Not signed.
No, your lordship, second page.
The second page.
It's an advice. Prepare for death.
Preparing to die. He said that's the most inevitable thing, but nobody plans for it.
So we must thank all of you because I think you're all acting pro bono.
Yes, yes.
So that is something which is hope for you. You have spent so much of your time,
No.
Nataraj, all of you.
It's always pleasure.
We think only when we go to
For the benefit of.
when we go to the cremation ground, looking for it. Immediately coming out the cremation ground, everything is over.
My brother wants one thing to be added.
Yes.
Is that registry will communicate a copy of this order to all the high courts.
Yes.
So that, they are made aware.
Because the report may take some time. The law reports may take some time.
That's right. So
Because they have to formulate rule for storage.
Yeah, you're absolutely right.
the registry will communicate a copy of this order to the registrar generals of all the high courts.
Yeah, lordship added a sentence, the high courts may formulate the rules expeditiously so that they also complete.
What is that rules?
No, about storage,
Storage of these
that's para 200.
books.
And my lord, doctor says also to the CMOs of the district.
It should go to the chief medical officers also.
Yes.
Go to the chief
Mr.
medical
Natarajan.
officer.
Medical office, yes, we'll,
It should go to the
yes,
chief
we'll
medical
also go through our,
and perhaps
But how many CMOs are there?
Can I say one thing?
communication.
we'll get it up, we'll get
And
it.
let the high court registry send to the CMOs in that district, that will be easier, instead of we sending it to 600.
That's right.
No, not you,
That will be
but
better.
central government should
We'll
also,
also get
Yes.
it.
from their.
Yes, from our end, we'll get it.
Let it go to the
Because
I
the
could tell
CMOs.
health
will not come under
secretary.
the union order.
Yes.
of each state.
At least the
High court and
information
the
should,
No, my lord, just
or you
suppose
can
you're saying
put
high
the-
court and health secretary.
the health secretary.
That's right. So if it
The health secretary,
copy will be sent to the high court.
health secretary for
So let them
communication,
do it. Let them
for
do it.
communication.
Health secretary
That's
for
not our
upward communication to the CMOs.
The registrar general of the high courts will dispatch a copy of this order to the health secretaries in the respective states. Union territory, you'll have a union territory also. So.
Lordship will say for onward communication to the
For
CMOs.
onward communication
To the respective- all the CMOs in that.
to the CMOs in the state stroke union territory. Anything more?
That's
At a,
Indian Society of Clinical Care Medicine, with the appellant, I want to thank you, Your Lordship.
You're just doing our duty.
It was a long way patiently.
Yeah, let us see how it works. That's right, that's right.
brother Joseph. One thing. Justice Joseph at a particular moment said that when the patient is suffering end stage and there is difference of opinion, that gave rise to a certain scenario in my mind. Suppose the spouse is there and they have suffered each other such a lot. The spouse is saying, no, you must immediately act on it.
Immediately packed on.
And other will say, I'm the happiest man.
But in a lighter vein, it was said that Winston Churchill was told that his opponent
Yes.
was suffering for some illness. So he said, I hope it's not something minor.
And if I was,
Won the
free, I
Nobel
would-
Prize for Literature.
But that's for history of the English speaking people, not for the war series.
That's right, that's right. Yeah, that's right.
He also, is it for peace as well?
No, I think he got for literature.
He got Nobel Prize for literature.
For literature.
But Lordship, he wrote those 5 volumes on the war, Gathering Storm, this, that. But I was told that he won the Nobel Prize for his book on the history of the English speaking peoples.
Have you
People with plural, yes.
Yes, people.
Yes, there's a collection of his speeches.
Yes.
Have you read just
Standing.
Churchill's
There's also
letter?
DVDs. Huh?
Churchill's letter for his son, written to his teacher.
No, I don't know.
I think it's a thought which one.
Pinnacle, I mean,
Yes.
how very reaches.
Yes.
Even G.K. Chesterton's letters to his son.
Oh,
his letter for his son
Outstanding,
written for a teacher.
In fact, Justice
Like
Nariman,
what he want his son to develop in the passage of time.
in fact, my lord, Justice Nariman,
Orthodoxy is book, Orthodoxy.
who's Churchill.
Churchill.
DK just said it.
Yes, Orthodox.
Lovely, lovely.
But only one since we're ending, my lord, the Justice Nariman, we did a service tax on clubs. So the clubs are mutual associations. Can you have service tax on clubs because they are providing the mutuality? So there's no question of service provider.
That's right.
So Justice Nariman starts with the thing where Churchill was a member of the Bangalore club when he was
Yes,
in
yes.
India, and he has not paid his dues.
That's right.
He's in arrears.
Bangalore club.
He's a defaulter.
He's in arrears. He's a defaulter. You're
That really
I'm not a
says that-
defaulter of any of my.
You're a fan. You're a fan. All right. So we're back to, thank you.
Please, great.
I'm fond of golf
Arbitration, yes.
and I'm a member of so many clubs, but I'm not a defaulter.
He wants to show a Babur's letter to Humayun.
Different.
Whatever it is, you can say.
There's a letter on different subject. Babur's letter to Humayun.
Okay.
What you have to keep.
See,
Is there burden on net?
Somebody's life is in your hands. You miss out on one word, you lose. You will be responsible mentally. Yes.
Hit your burden.
Yes.
but that's not on death. So how to run?
Yes.
Please follow.
Yes. It's good for the document.
Essentially, what has been argued before my lords is that the only thing coming in the way of smooth arbitrations
So you were saying section
But
9
I'm
and
saying that what the main argument appears to be that what is coming in the way of smooth arbitrations is the Stamp Act. My lord, I am saying that Stamp Act deficiency, my lord, if the sections are not complied with, that is a minuscule portion of many, many vast agreements in the commercial world. Today, like Suraj plants, if this honorable court says that the matter cannot be referred to arbitration or a section 9 relief cannot be granted, there is no way, my lord, in which the sections and the stringent sections, I would say, of the Stamp Act are not complied with. And there is no reason for them to not be complied with. Because it is not just about, my lord, the state losing revenue, but it is also about the feeling that one can get away with it, can possibly get an interim relief under section 9, can also wait it out. My lord, section 9, subclause 2 has not been considered in these judgments.
Let us see that.
My lord, which says that within,
Give it. You give the whole set.
my lord, in the course of my arguments, I will again come to 9.2, but my lord may see it.
Yeah,
My lord is seeing that 9.1
yeah.
is a party made before or during arbitral proceedings. So, my lord, not just before, but also during arbitral proceedings, the section 9 relief can be granted, or any time after the making of the arbitral award. So, my lord,
Just one.
You take actually, so that we.
my lord, then because my lord, I have to show bottom landscapes in some detail because that is the judgment.
I just want to say one thing, my lord. If we are to go into, my lord, the reference was actually very narrow. My lord, if we are to go into section 9, that will expand the scope. I can understand my learned friend has serious reservations about some aspects of section 9. I may or may not share them, my lord. But this may not be the forum to go into, my lord, the 9 aspects. Subject to that, your lordships may go into it. Then I'll address your lordships on section 9. Because otherwise, my lord, then we go to, we keep, my lord, going into a large number.
Her apprehension appears to be
That
our ruling on the
may affect. Your lordship may make it clear.
Direct impact on.
Right. I'm saying, my lord, your lordship may make it clear. According to it, will have. I can show that 9 has a different regime, and 9, my lord, may be treated separately. I may agree with some of what my learned friend says, but my lord, this may not be
necessary to go into it.
Lord, I would say that I must make out a point on section 9 because, my lord, it will have some consequences. And the learned amicus may also point out to the court what these ramifications might be or might not be.
Let us
Yes.
Ms. Tiwari, you see, we are sitting in a reference.
Absolutely.
Right? Now, perhaps the amicus might have confined his argument, limited to what is referred. And suppose this section 9, it will definitely or may have an implication. One is not ruling that out. But such an argument has not come forth from the other side, or rather the amicus.
Rather the amicus, I would say, not the other side.
No, amicus, I should.
Amicus,
Yeah, correct. I have immediately taken back my word. There is no other side. There's only amicus we have heard so far. So when I say
amicus has made a point of it.
No, correct. So the amicus has now made a submission. Then we have to open it. You can't be just, sort of.
2 things, my lord, I'll say to that. One, that I will show, my lord, from the judgment itself, that why indirectly the reference is also then to section 9. And I will also show to my lord that in global 11.6a was not being considered or was not argued and yet considered, my lord. It was an section 8 point. And my lord, then there was a reference, there was an 11 also, but my lord, 11.6a specifically was not argued. It was considered. And my lord, when this reference is made, the paragraphs of Garware which are referred, my lord, and the paragraphs of Vidya Dolia which are referred, my lord, that has a direct implication on referring 9, my lord. Because, my lord, in para 37 of NN Global, 9 has completely been discussed and decided. That is the issue today, my lord.
Where is that portion?
Yes,
decide. Let us see that.
Para 37.
Let us see that.
Let me just clarify this, my lord. Neither in Garwan, my lord, 4 paragraphs are referred, my lord. 22, 29, 146, 147. Garware is only a section 11 case.
Because why we are asking you this question is, there is one reason. You see, section 9 permits a party even before the commencement of the arbitration.
Yes.
To seek what is described as urgent interim relief.
Yes.
Correct. So if that, even at that stage, if the mandate of the stand back is followed or not followed.
My lord, that's a live question, my lord.
No, what you're saying is the impact is even more
Because if you say that
Maybe,
stamp back should not be, it should be deferred to a later stage.
I am not
What
saying.
will happen is the interim relief will get.
No, Manoj, I want to
First
make
of all,
this.
it is to a court.
Manoj, yes, there are differences. Manoj. There are serious differences between an 11 and 6, 11 and an 8 situation where the court simply pushes the matter to the arbitrator, and a section 9 situation, which my learned friend is arguing, which may require the court to actually look at the document.
Section 8 is slightly similar to 11.
11. So 8 and 11 is.
So you are actually pushing it there. You have to prove the existence of a valid agreement.
So Manoj, that is one bucket.
Ah.
8 and 11 is
8
one
and 11
bucket.
go together.
Yes, that I understand. But Manoj, 9 is actually a little different because 9 requires some interim adjudication on the substance of the matter, on the merits. Well, not prima facie, you have to look at the document, you have to give interim relief, not give interim relief, whether at that point you will insist as a precursor to, my lord, stamp duty. For instance, I've got.
Your short point is that in a section 9 proceeding, it will be fair.
It may be different.
To insist that the stamp back is enforced.
My lord, in fact, there are judgments. I can, my lord, say in her favor.
We should not.
It appears that during the pre-lunch section, you said that the stamp act have a different application under section 11 and 8 and 9.
8 and
You cannot have a different application.
9
that you made such an.
9 is a situation, my lord.
Please question that, my lord.
They cannot have.
9 is a situation. I'll give an example. No, I have some order.
What the 3 judges bench says about 9.
No, 9, the 3 judges bench in one paragraph.
Let's see the paragraph.
Right.
Let us
see that paragraph. One, my learned friend at please.
Where is the judgment?
Para 37, my lord, NN Global.
Para 13.
Has our compilation is page
283. 283.
Yes, my lord. It's a different compilation that my lord.
Your comment.
I'll not see it from my compilation, no? The same paragraph.
Which paragraph you want to read?
37. 37.
37.
In the case of an application under section 9 of the Arbitration Act, my lord has it?
Yes.
1996.
Just a moment,
Yes.
let my brother get. Page for 330.
Oh, not in my.
This new one, it is
330. It is 330.
First,
330 in my opinion.
Yes, you got it. Yes, everybody's got.
The situation would be different if an application for urgent interim reliefs is filed under section 9 before the court and it is brought to the attention of the court that the substantive contract is not duly stamped. The court would grant ad interim relief to safeguard the subject matter of the arbitration. However, the substantive contract would then be impounded and the party concerned be directed to take the necessary steps for payment of the requisite stamp duty in accordance with the provisions of the relevant stamp act within a time-bound period. It is made clear that the payment of stamp duty on the substantive contract as assessed by the collector would, however, be subject to the right of revision appeal available under the relevant stamp act. My lord, this is where the problem is. And now if my lord may just see para 26 of the same judgment on page 327 of my compilation.
Yeah.
To see, my lord, how it is in contradiction. 37 is in contradiction to para 26. In our view, there is no legal impediment to the enforceability of the arbitration agreement pending payment of stamp duty on the substantive contract. The adjudication of the rights and obligations. My lord, this is important for 9. Because in 9, the adjudication of the rights and obligations is happening on the substantive contract. The adjudication of the rights and obligations under the work order or the substantive commercial contract would, however, not proceed before complying with the mandatory provisions of the Stamp Act. My lord may see the contradiction between 26, where it says adjudication of the rights and obligations under the work order would, however, not proceed before complying with the mandatory provisions. And my lord may see para 37, where it says that section 9 relief can be granted.
What the court perhaps had in mind was that interim relief under section 9 is viewed differently from the actual adjudication by the arbitrator. That this is a matter which, because of the very nature of the jurisdiction to grant interim relief, it must be exercised immediately. Whereas adjudication of the main dispute, to resolve the dispute between the parties under the arbitration agreement, that should await actually the impounding payment of duty, etc. This is, I think, what we could make out from
No, that's what the Honorable Court was trying to say.
Correct.
But my lord, I will,
So-
I will show that the basis itself was wrong. Because the substantive contract has to be seen.
Go with it. Suppose sometime you want to register something. Okay, you know, we want to try.
My lord, morning I can.
No, if you can conclude with half an hour, we can.
My lord, it'll be difficult because I will take some time to show at least 3-4 judgments, my lord. That's all that I'm showing, and the background, my lord, what my lord observed on why the court thought that it can be given the interim relief in this manner, my lord. The background to that, my lord, I wanted to show from the judgments. So just 2-3 judgments more.
One, I need about half an hour, my lord.
And then who else is there? There's nobody else.
Interveners will require around half an hour for the arguments and only address the questions which fell from my lords.
No, do you have anything new to add?
Yes, my lords. Only to address those questions which fell from my lords.
So briefly, just tell us in two minutes, what is your line of argument? So we'd like to know.
Our line of arguments would be, first of all, limiting to Section 5 of the Arbitration Act, which is corresponding to the extension of the doctrine which my learned friend from the opposite side has argued.
Who is from the opposite side? Because we don't.
My lords, the respondent.
Standing on the other side.
Yes. And secondly, my lords, the other issue would be only limited to the later law and special act, the Arbitration Act being the complete code in itself.
Therefore, you're saying duty need not be paid. The court need not go into this.
Yes, my lords. Interpreting the provisions of the Arbitration Act, stamp duty may not be paid in the Section 11 stage or in the Section 45 stage.
Need not be paid.
No, stamp duty is required to be paid at the time of execution of the agreement, not at 11 or.
If not going to.
We'll satisfy your lordships. Even on.
We want to know which side of the sort of line you are in.
Let's
go.
This side. Not one.
Continue tomorrow because it's not. You don't want to sit there. It's not going to no purpose.
Probably, your lordship, tomorrow, WhatsApp will come after this Madhuri Diwan's marriage.
That's all we can do. Where is Madhuri Diwan?
No, her matter is next.
That's Joseph Shank.
Joseph Shank.
Where is she? We wanted to know whether, she had said that she might report, that the matter doesn't require any adjudication. That's why we asked her.
We'll be ready.
Now, you're in the WhatsApp?
Yes.
Now, what is it?
WhatsApp's a new rule is on the unveil.
No, there's a bill already in Parliament. Section. There's the first bill, but there's the first bill it was withdrawn.
That's right.
Then again a new bill has come.
That's right. So it's going to be argued, or we thought that.
Because the other side had said that even if the bill is there, we want to argue. So I don't want to say anything. We place the matter, then lordship may decide whether you want to.
No, but issues in the bill, do they overlap with the arguments?
Yes, we have made a chart also.
You're appearing for WhatsApp.
I'm appearing for Meta. Mr. Sybil is appearing for WhatsApp. Meta is the parent company. It was earlier.
Facebook.
Now it's called Meta.
It'll come tomorrow.
Mr. Banerjee, this para 37 and 26, I think.
Right.
What Ms. Tiwari has pointed out, although it is not specifically referred, it might have a bearing. You have to just reflect on that.
I'll reflect on that, but for that, then your lordships will have to go into the Section 9.
So that's why we are just looking at.
There are 8 or 10 judgments on Section 9.
We are reaching a closure or not, we are just looking at.
No, that's an important question because 9 is otherwise pending in matters here, my lord.
Oh, because it is pending.
Yes, my lord. It is pending in a couple of matters, I know. And in one matter, SLP was filed, notice was issued, it was settled. The full bench judgment. So, my lord, it is pending in two matters, at least in which I am.
So there in section 9, what's your argument that stamp duty will have to?
My lord, there the trend is a little different. There, what the courts are doing, my lord, is that as a condition of giving interim relief, they are attaching this as a condition. My lord, there are some Calcutta High Court. My lord, there's a parallel of 39, 1 and 2. There, the thinking is slightly different, my lord. Here, the thinking is push it to the arbitrator. There, the thinking seems to be slightly different, that you give immediate interim relief, because otherwise, my lord, if you are looking at stamp, then the matter goes. But in the meanwhile, somehow protect the revenue as a condition.
One cardinal difference is the absence of a clause like 6A.
6A is not there, my lord, and
6A is not there in 9. So
and even 8, my lord, the words are that it is only the validity. Neither of those phrases are there in either, my lord, in 9, in 11, in 9.
9.
So, my lord, 9, I can address your lordships on 9, my lord. I have the 7 or 8
judges. How it times out after hearing her for some time, we'll get to know.
It's a little, my lord, that will expand the scope of, because the reference, as I read it, my lord, was only because there was a conflict between two judgments. This portion, my friend may not agree with, but there was no.
Garware, the other one is overruled, and then
Garware is 11. Garware is 11. My lord, SMS is 11. Vidya Drolia is 11/8.
Correct.
Here, my lord, there is some observation on 9, but my lord, that was really not, my lord, the conflict. It is one view which a 3-judge bench has taken. It may be right. It may
All right.
What is only one thing, my lords, on section 9 specifically,
Yeah.
there is an earlier view of your lordships, because the whole thing boils down to one question. It's a temporary affliction. In the context of temporary afflictions, how have your lordships looked at it? There are your lordships' own judgments. So, my lords, I'm sorry I wasn't there, my lords, for the intervener. Tomorrow, my lords, all I will beseech your lordships is give me a little time. I'll take your lordships through the scheme of the act. Because what is necessary?
Going to lie on which judgment?
So, my lords, first judgment is firm Ashok traders.
Please give us those.
I'll give that. This 2004, 3 judges. What your lordships did in that case, if I can just
help, so that if
I know, my lords, and I'm just describing, my lords.
You've already given a
Yes,
compilation.
that's the judgment I was talking about.
Which is the compilation? Let us see. Otherwise, you'll again take.
My lord,
This is a compilation.
My lord, this is file
2004, volume 3, SCC 155.
No, this is compilation of judgments 2.
Yes, 1 and 2.
I mean, 1 and 2 means you have rounded up at 36 judgment.
My lord, this is a volume of 25.
Which volume is this 36th judgment? This is 36 judgment, is it? Naina Takkar, it begins, Annavur Purna.
Yes. It's 26, Nena.
That's right, but you end with 36. You're going to refer to all these judgments?
No, not at all, my lord. This was initially what we had prepared.
So you tell us which are the judgments you're going to rely on, so that
Yes,
we get an
my lord,
idea.
my lord.
So,
Otherwise, if you come tomorrow, we'll.
No, my lord, we'll only point out, I said, my lord, that 4 judgments, which are the main judgments, and apart from that, 3.
Which are those judgments? Please tell us.
Yes, my lord. My lord, Gotham Landscapes, Garware.
Just a moment.
My lord.
Garware, okay. Just take that down.
My lord, I'll just say it from the index itself. My lord has the index.
We don't have the index, that's a problem.
No, it is there. First page.
You're talking about this?
Yeah.
It's 3 and 4.
3 and 4. Item 3, item 4.
Gotham Landscapes, Garware Wallropes, Vidya Rolia, NN Global.
That is 4.
My lord, 3, 4, 5, 6. Then 8, my lord, Hindustan Steel versus Dilip Construction.
All right.
9, United India Insurance.
Hindustan Steel is for what purpose?
My lord, Hindustan Steel also has been referred in these judgments, and therefore, my lord, I want to just show that why Hindustan Steels, my lord, could
All right. 8. Then
United India Insurance versus Hyundai Engineering.
we have reached now 3 plus 3, 6 judgments you have referred to.
Yes, my lord.
Yeah. Then
My lord, apart from that, firm Ashok Traders at 23.
What point is that?
My lord, firm Ashok Traders say that a section 9 relief, my lord, will not arise from the contract itself. There's a one-line observation there, which my lord ultimately Gotham Landscapes uses to say that therefore for section 9 you will not look at the substantive contract at all.
this Gautam Landscapes, is it overruled? No.
My lord, partly overruled by Garware. But the principles on which 11 has been based, exactly the same principles 9 has been
No,
based.
my lord.
Decision.
With utmost respect, may I just say in one line, the question your lordships is considering is what happens if there is a temporary affliction. In firm Ashok Traders, what happened was there was a dispute under a partnership agreement. The partnership deed, when it was relied upon and a section 9 is filed, the effort made is no, you cannot grant relief because 69(2) comes in the way. It's an unregistered partnership. Now, what your lordships noticed in that judgment and why I am relying upon it as an intervener is to create an equivalence to show there also the registration is a temporary affliction. Let's say I were to register a partnership today and I haven't registered it. I may register it a month down the line and tomorrow morning there's a dispute and I am told no, you cannot seek relief. Now, what if I were to register it day after tomorrow and come back? The affliction goes away. What your lordship said in firm Ashok Traders is 69 will not stand in the way because what we are doing is we see that there is an underlying contract. It is a partnership deed, but we are not bothered about it. We are culling out the arbitration agreement from that to give relief. So that is, my lords, I want to show that tomorrow.
These are the judgments you wanted to rely on.
Please, man.
Correct. So-
Most of these I have cited, my lord. United, Hyundai, Dilip, all these have been cited, my lord, except for, my lord, I have made some guidelines. Your lordships may have a look at it.
Hand over tomorrow.
I'll have it. My lord.
Yeah, that's it. Yes, give it. He wants to read it. Yes.
Grateful.